Hello, everyone. I believe we shall start soon. I just wanted to say hello to everyone, and I will turn on the camera closer to the moment of the beginning, but I hope you're all good and everything is working.
Hello, Aglaya. That's fine from my end, at least. I look forward to talking to you now.
Hi, Aglaya. I'm not Yury. I'm just testing the system. Can you hear me?
Yes, hi. Hi. Yeah.
Okay, great.
Hi, Aglaya.
Hi, Mark. Hi. It's nice to see you.
Good to see you. Yeah, I'm just checking my screen.
Hi, everyone. Sorry, before we begin, if I could ask the organizer just a quick technical question, if that's okay.
Yes, hi.
Hi, yeah, sorry. Thank you very much for the helpful guidance you wrote to us over email. Just to double check again, the speakers are also kind of co-organizers in this call. We don't have to unmute them for them to speak. Just to clarify.
Yes, they can control the camera and the microphone.
Perfect. Thank you so much.
Mm-hmm.
Hello, Aglaya, everyone. I'm just testing my
Hi. Yeah, we can hear you and see you as well.
Perfect. Thanks.
Hello, everyone.
Hi, Farouk.
No. Hi, greetings.
Hi. Hi, everyone, once again. I believe that all of the speakers and moderators have now joined the session. So unless there are any objections on your part, we could begin, hoping that others would join. I think I should take it as a yes. Vishakha, unless you have objections. All right, well, thanks again, everyone, for joining today's panel. It really is a pleasure, and I really have to say an honor to be co-moderating the discussion of such truly stellar panel. So kudos to the organizers who have invited such amazing speakers. It is also an honor to be co-moderating the session with my wonderful colleague, Vishakha, who is, along with me, the co-author, and our other colleagues, the co-author of FDI's 2021 Moot Problem. So just before introducing our speakers, I would just like to say that I hope that today's discussion sheds some light on why so much ink has been spilled on the issues such as, the jurisdiction of the state-owned enterprises before the investor states tribunals, especially those constituted under ICSID, and the intricacies of the interrelation between certain tests that may be applied for determining standing of such claimants before those tribunals, and rules of attribution and maybe even state sovereignty. We also hope that we will elucidate on some practical implications of investor-state arbitration involving such claimants. I will now briefly yield the floor to Vishakha to make some remarks and to introduce some of the speakers.
Thanks, and thanks to both our panelists and our attendees for joining us today. As Aglaya mentioned, over the next 90 minutes, we'll be touching upon, hopefully, a number of issues relating to the rights and treatments of state-owned enterprises in investment arbitration. And this should be of great interest, not just to those of you participating in the 2021 FDI moot, but also all those of you who are interested in the field of investment law and investment arbitration generally. So in that spirit, I'd like to introduce a few panel members who the Russian Arbitration Association has kindly assembled for today's discussion. We have with us Ms. Olga Tsvetkova, who's a counsel at Egorov, Puginsky, Fesenev and Partners and co-heads its international arbitration group. She has over 13 years of experience handling international disputes in a wide variety of sectors. Olga is also a former deputy head of the International Law Department of the Russian Ministry of Justice, where she's represented the Russian government in both investment arbitrations and treaty negotiations. Among our panelists is also Professor Mark Feldman, a professor of law at Peking University School of Transnational Law. He has previously served as a member of the T20 Saudi Arabia Task Force on Trade, Investment and Growth, and as a member of the E15 Initiative Task Force on Investment Policy. Professor Feldman has also been a chief of the NAFTA-CAFTA-DR arbitration in the Office of Legal Affairs, in the Office of Legal Advisor, at the US Department of State. And in the private sector, he has several years of experience at Covington and Burling. Also joining us today is Mr. Yury Babichev, a partner at Bryan Cave Leighton Pesner, where he focuses on international arbitration and cross-border litigations. He has several years of experience in commercial and investment arbitrations, fraud and conspiracy claims, derivative litigations, shareholder disputes, and other special situations involving multiple jurisdictions. Aglaya, perhaps you would like to introduce the rest of our panel.
Absolutely. Yes, I would like to introduce Filip Boras, who is among the speakers today, who is a partner at Baker McKenzie and heads the dispute resolution practice of its Vienna office. Now, he's a dual qualified attorney in New York as well as Austria and represents clients in various international investment arbitration proceedings before major institutions and ad hoc tribunals. Filip is a leading lawyer for dispute resolution in Central and Eastern Europe and has extensive experience representing clients in also post-merger acquisitions and corporate disputes. Filip also is a member of the advisory board and the former co-chair of the Young Austrian Arbitration Practitioners, executive committee member of the international section for the New York State Bar Association, as well as the member of Belgrade Arbitration Center. Next is Farouk El-Hosseny, who is a senior associate at the Three Crowns in London. He focuses on complex commercial disputes and the investor-state arbitrations, predominantly in telecommunications and oil and gas sector. He also regularly advises clients on arbitration proceedings under the ICSID rules, as well as ICC and UN Central Arbitration rules. Farouk was formerly with the Freshfields office in London, as well as the corporate and M&A practices of the firm in Dubai and in Riyadh, and was previously also a legal counsel at the Permanent Court of Arbitration, where he administered appointing authority requests, investor, state, and commercial arbitrations. And I should also say that Farouk holds a PhD degree in public international law from Leiden University and was formerly a visiting scholar at the Lauterbach Center of the Cambridge University. So this is the stellar panel that we have, as you can see. And without any further ado, I'd like to proceed with kind of opening general policy-wise question, if you will. So what, in fact, is the reason that we should treat the state-owned enterprises differently as claimants in the investor-state arbitrations before the tribunal is constituted under the older generation BITs, and specifically also differently under the ICSID tribunals? And as put by one of our speakers in the preparation for today's panel, simply put, what would be the difference in such context between ExxonMobil and Saudi Aramco? I believe that I could now yield the floor maybe to Mark to make some introductory remarks, and then to Yury as well as other speakers.
Well, thanks so much, Aglaya, and Vishakha and the organizers as well. I could offer a few preliminary thoughts on SOE claimants, and I think that it's important at the outset to analyze the ICSID convention separately from investment treaties, because the ICSID convention has a distinct history, which should inform analysis of how to approach SOE claimants. Importantly, the ICSID convention excludes state-to-state disputes, and the ICSID convention excludes state-to-state disputes for several policy reasons. The first is that the ICSID convention was meant to fill a procedural gap between state-to-state disputes, which could be submitted to the ICJ, and disputes between private parties, which could be submitted to commercial arbitration. The second policy reason for excluding state-to-state is that the ICSID convention was meant to depoliticize disputes by removing the home state from the process. And this policy is reflected in ICSID Convention Article 27, which bars contracting states from providing diplomatic protection in ICSID cases. The third policy reason for excluding state-to-state disputes is that the ICSID Convention was meant to encourage private as distinguished from public foreign investment, given the importance of private foreign investment for development. And recall that the ICSID Convention was an instrument developed by the World Bank. The World Bank was advancing its mission of international development. These policy reasons for excluding state-to-state disputes under the ICSID Convention support treating SOE claimants differently under the convention, in the sense of confirming that a claim brought by an SOE claimant does not, against an ICSID contracting state, does not give rise to a state-to-state dispute. But investment treaties, unlike the ICSID convention, generally do not have such a clear history with respect to excluding state-to-state disputes and the policy reasons for doing so. There are many possible reasons why policymakers might want to exclude state-to-state disputes from investor-state dispute settlement mechanisms, or alternatively, might want to impose special rules on SOE claimants. Those policy reasons include the three ICSID convention policy reasons that I mentioned: the availability of state-to-state dispute resolution elsewhere, removing the home state from the process, encouraging private foreign investment. But policymakers might have reasons in addition to those ICSID convention reasons for excluding state-to-state, or at a minimum treating SOE claimants differently. So for example, in many recent trade agreements, there are disciplines on SOEs, and those SOE disciplines are driven by a policymaker interest in encouraging SOEs to pursue commercial as distinguished from governmental ends. Although there are many reasons why policymakers might want to impose special rules on SOE claimants, most BITs, in fact, are silent on the issue. Under such BITs, the question becomes whether special rules should be applied to SOEs, even without specific guidance from policymakers. On that point, I would encourage tribunals to exercise caution before applying special rules to SOE claimants in the absence of specific policymaker guidance. I also would add a few thoughts with respect to the two factors proposed by Aaron Brockus for determining when SOE claimants can submit claims against states under the ICSID Convention. The two Brockus factors, whether an SOE is acting as an agent of the state or discharging an essentially governmental function, closely resemble customary international law rules on attribution as reflected in, respectively, ILC Articles 8 and 5. While Aaron Brockus did not elaborate on the agent and governmental function standards, content for those standards can be provided by well-developed jurisprudence applying ILC Articles 5 and 8. Content for the Brockus factors also is being developed through application of the factors by investor state tribunals. On this point, I would emphasize the importance of applying the Brockus factors separately. When considering control, focus should be on control. When considering governmental function, focus should be on governmental function. I also would note that in the context of SOEs investing abroad, the control factor likely will be the more relevant of the two Brockus factors. In an attribution context, the relevant SOE conduct normally will concern conduct in the SOE's home state, where it would not be surprising for an SOE to exercise public functions of a legislative or administrative character. But in an SOE standing context, the relevant SOE conduct normally will concern conduct in the host state, and it is not at all clear how an SOE acting abroad in a foreign jurisdiction might be exercising administrative or regulatory authority that has been delegated by their home state. Thank you again for the opportunity, and I look forward to our discussion.
Thank you, Mark. So we will touch on those issues that you mentioned in your introduction later on in some of our questions, hopefully. So Yury, maybe, or other panelists, would you like to also comment on that?
I thank you for inviting me, and thank you for assembling such a great panel, and then Mark, and to Mark especially, for setting the floor for the discussion. I can echo the point he made that the history of the ICSID convention should be really taken separately, because it had this specifics related to the aim to diplomacy. So make take the disputes between the states outside of the realm of the convention, while as to the definitions of the investor and many bilateral or multilateral investment protection treaties, I think as Mark rightly pointed out, the majority of those, they still don't expressly distinguish between the state-controlled companies and private and purely private companies, and but they also, many of them would also have their own history of negotiations, or some of the states, they would have their own usual regular template, or with which would be they would start negotiating those bilateral or multilateral treaties with the other states they were entering into. So basically, when you look at those issues in practice, you look at the text of the specific treaty first, and usually it is quite clear on its face. And my general approach would be an advice that you don't necessarily exclude out the state-controlled companies or state-owned companies from the definition of the investors, unless they are expressly excluded. And we do see sometimes in practice, including myself, that some like the parties or the tribunals may refer to examples of the treaties where state-controlled entities are specifically mentioned as investors, same as the sovereigns themselves. As an example, that if the other treaties don't expressly mention state-controlled entities as investors, so they should be excluded. I think that's probably not the proper way of interpreting the majority of the treaties, which don't make a distinction, at least not an express distinction between the private companies and state-controlled companies as investors. I think the point I would add to what Mark mentioned is some of the bilateral and multilateral treaties, they actually do make a distinction for the disputes as between the investors and the host states, and disputes between the host states as to the interpretation of those bilateral investment or multilateral investment treaties, because usually the states would not submit to the arbitration in relation to the disputes between the two of them. So that distinction made in respect of with respect to exit convention sometimes could be relevant for bilateral investment treaties as well. But I would also add, I think what's important to have in mind is when those treaties negotiated and entered between the specific states, is that you look at the economies of the respective state parties to the bilateral investment treaties to see what's the economy structure is, in the sense that, like, taking the example of the Russian Federation or China, for example, there is a lot of economy is largely dominated by state-controlled or state-owned entities. So the major flagships of the economy, they would have either very substantial and pretty often a controlling shareholding stake in majors in various sectors of the economy. So it will be I think a wrong assumption to think that if the Russian Federation is entering into, or China as well, is entering into a bilateral or multilateral investment treaty, that without specifying expressly that its state-controlled entities are captured, those should be excluded. Because the whole point of the states to protect their investors, and if it happens so that the major investors are actually state-controlled, why shouldn't, I think some assumed intention should be that the states would want to protect their state-controlled companies as well.
Sure, unless, thank you very much, Yury, and again, Mark. So unless other speakers would like to comment on this kind of.
Aglaya, just one point for me, if possible. Okay. I think obviously Mark and Yury covered most considerations, which I echo, because there is just no good grounds to differentiate as such between state-owned entities as investors and all other investors unless there are specific restrictions or unless we are within exit context. But an interesting angle for me, and I know there are no questions on that, at least in the draft questions we had, is whether, if we distinguish whether state-owned entities should be subject to any other protection under BITs, being, for instance, diplomatic protection claims, which some commentaries and some case law affirm as possible under treaties. Meaning when a state file a claim for diplomatic protection on its behalf or on behalf of its specific investors against other state, and then the tribunal find jurisdiction to consider it. We have such case law that was a claim from Italy, and I understand that was jurisdictionally successful, though not on merits. And I guess there is just another issue to look at outside the context of today's webinar, perhaps, and perhaps outside the context of FDI problem, but in practice.
If I could jump in on this while we are still talking about policy and not going into the detailed legal analysis. I mean, I fully agree with what was said, and I agree that absent to any restrictions, it is difficult to read any into a treaty. But I'm just wondering whether, when we look in particular to older treaties, whether the drafters of those treaties really have considered the issue, and whether the missing of any language in a treaty makes us to conclude easily that there is no restriction, especially looking into the background why this was, why those treaties were actually concluded and how they were concluded. And that, at least for some, especially Southeastern European states, you can see that not much was thought was put into it. And I see it regularly when we look to the Austrian treaties concluded with Southeastern European states, that the travaux are very, very thin. And so only because now a specific restriction is missing, or on the other hand, a specific mention of governmental entities, governments, or whatever is also missing, how can we actually do a proper analysis, especially with the background, with the question in the background, do state-owned enterprises really need the protection of bilateral investment treaties? If one of the goals was actually to move those disputes from the political scene, is this goal even achievable in the case of a state-owned enterprise? Or will the state automatically then be involved in the dispute also on a diplomatic level? And so this, at least one goal of bilateral investment treaties would seem to me at least difficult to achieve.
Yeah, if I may jump in on the, just what Filip just a comment that made. So if I understand you correctly, the idea is that if the state-owned enterprise is a claimant, you would implicitly think that its home state as a shareholder would often be involved. I think I can extend this point further to show that if you have a national champion, I don't know, like Facebook, and the US government is, to my knowledge, is not a substantial shareholder in Facebook, but the state has other means to be interested in the well-being of its national champions, because the state can get money out of those companies through taxes. So the states may always have an interest in protecting their national champions, national investors, whether those are private or public. When it is a state-controlled entity, there's just extra element because the state is a shareholder. It may, in theory, get some dividends. And if the state-controlled company was, I don't know, deprived of its rights or its assets in the host jurisdiction were expropriated, derivatively, the home state is also affected. But I think I may be wrong, but I think the history of the bilateral and multilateral treaties was basically to take away those from the diplomatic protection. So when the state would need to engage with the other state in discussions, so give a tool to companies, to entities of private law, commercial enterprises, to protect themselves. And that was the purpose, because I think in the 19th or 18th century, if, I don't know, a British company was affected somewhere in the colonies, the monarch would just simply send the troops to fix the problem they had in, I don't know, in the United States or in the former colonies. And the answer to it, the policy question to it, why would, I don't know, young boys spend their lives, die in local wars to protect the business interests of some companies? So that's how it was centuries ago. Then it went into the diplomatic protections. Is like, well, we don't necessarily launch a war if our companies are affected. And then I think it's after the World War II where the idea was, okay, we don't want to have these state-to-state discussions being implicated with what's happening with some of the commercial interests of our own companies. So if you have this goal in mind to decrease the level of, because the other way around, if the state-controlled entities don't feel protected by the investor through the investor-state arbitration mechanism under the investment protection treaties, they would need to resort to the diplomatic protections. So they would need to use that tool which was available to them, I don't know, half a century ago. So in this regard, my point would be that regardless whether it's a state-owned or purely private investor, the rationale, the policy behind of those being protected by the investment protection treaties is the same. is to have less of those disputes escalated to the level of respective governments.
That's a very interesting sort of debate going on about policy rationales. And I think one of the sort of basis for this would be, again, as Mark mentioned, if there were certain concerns of special risks that perhaps SOEs pose to the system of investment arbitration. And to that point, I see a question from Chris Campbell in the chat, who is the director of the FDI Moot, where he talks about, is there a risk of us overstating the relevance of the question of standing of SOEs or rights of SOEs when it comes to international investment law? Chris also points to how in the World Bank system, states have obvious interests in the protection of SOEs, and how national insurance entities, which are often allowed subrogation rights, may also be state-owned or state-controlled. So given that the system seems to have accounted for the presence of SOEs to some extent, I was wondering what the panel thinks about whether the issue is perhaps given more credence than it deserves. Perhaps we could have Mark address that, given his immense body of work on this topic.
I think Mark is having some connection difficulties. So perhaps someone else would like to take over.
I think I'm just looking at the Q&A session, and we had a couple of questions or comments. One was, is there a customary definition of the state-owned enterprise under investment law, considering that the definitions differs across different BITs? So what we look at, I think what mentioned here is broadly right, that you look at the shareholding, you look at the number of seats on the supervisory board, on the management board, and then maybe also look at some other informal means for the state to exercise influence over the activities of the respective investor. But as I mentioned, the trick with the home states as shareholders is that they can also act in dual capacity. So they can exercise their control through the shareholder means as a shareholder, but also as a regulator. So that, and the second one is basically applicable to all the individuals and companies which are within the jurisdiction of the respective home state. Speaking for myself, in response, what is there a customary definition? Personally, I don't know. Second, I don't think the one is needed, because when you look at the issues of who is the controlling shareholder or who is the majority shareholder, what are the rights given to a shareholder in a company, usually you would look at that at the under the laws of the home jurisdiction where the investor company is incorporated, because usually it has its own domestic law which would serve as a basis to understand and analyze whether a specific shareholder may have a control over that company. Speaking for Russian legislation, there are provisions in Russian laws which are quite flexible, but they give an indication as to which things may lead to take the shareholder of a company as a controlling one, and those are usually the majority of the voting stock, the majority of the seats on the board, or the ability even to appoint a CEO of the company. So just to sum it, I'm not necessarily, I don't think that it's the right thing to look at the international law to see for the kind of a universal definition, because the investors are different, companies are different, and under certain set of circumstances, one piece of legislation in I don't know may give a particular shareholder a control in, I don't know, in a French company, but that wouldn't be sufficient to give control over a German company, for example.
Thanks, Yury.
I see we
yes,
have
go
Mark.
ahead.
Perhaps, Mark, would you like to address the question in the chat about the risk of overstatement of the issues of SOE standing and their rights?
Yeah, sure. Can you hear me okay now? Can you hear me okay? Yes?
Yeah.
Yeah. So I think we absolutely need to protect the SOE's offensive interests. I think the real issue we have to keep in mind is this issue of removing the home state from the process. And so I think it's a matter of confirming in a given case, is the respondent dealing with a corporation or is the respondent dealing with ultimately the home state? And if the respondent is dealing with the home state, then that does raise concerns, especially under the ICSID Convention, given the clear policy goal of removing the home state from the process. So I think that's really the most pressing issue, is just confirming that the home state is not part of this process. The home state is not in the room in terms of the disputing parties working out their dispute.
Thank you, Mark. Yury, I guess taking a step back and a question relevant to the question that was addressed by Yury just before about whether there is a customary definition of an SOE. I also don't know that there is such, but maybe you could talk about sort of the differences, if any, in fact, that may exist between the sort of similar tests that are used in the context of standing, the Boras test, the agency and the discharging of governmental authority, also the tests under attribution rule under Article 5 of Articles on State Responsibility, which deals with attribution of conduct to the state of entities that also perform governmental authority, that are endowed by the law of the state to perform such. And also, thirdly, like a similar test used for sovereign immunity, which deals with sovereign authority, also of entities that are not state organs. So essentially, the question is, clearly those rules are different. They deal with different matters, but at the same time, they appear to be based on similar tests. So maybe Olga, Farouk, and others could speak a little bit about that. And if they are transposable or not.
Okay. Farouk, would you like to take a lead, or otherwise I will start?
Go ahead, thank you.
Okay, so a borderline for me, I will just comment on a couple of points. A borderline for me is that none of those tests actually is universal. For Boras test, it's restrictive, and we speak about it mainly in the exit context, while it is of course relevant also outside this context, but only as some guidance to look at. Regarding state responsibility and immunity, those are tests, again, obviously not fully compatible. They arise in different contexts, and when establishing a standing on a BAT of state-owned entity, I think tribunals should, and in practice, do look at activities that encompass just a wider spectrum of things, rather than required under state responsibility or state immunity tests, just because the purpose is different. The saying that it does not mean that we cannot take some elements from different tests to give ourselves and tribunals some guidelines, right? What can be implied under definition of this or that standard. And I would be happy for my colleagues to comment more on these separate elements. I'm just talking in general, that there is no settled framework, that those tests are not compatible, fully compatible, and were developed and should be employed in different contexts. at practical level, there are some helpful elements that can be employed. What is interesting for me also is that there are some approaches given in different tests that also can be quite helpful. For instance, in Web versus Ukraine award on jurisdiction, the tribunal considered whether the question that state-owned entity is an organ of the state should be analyzed and defined basically under international law or domestic law. They refer, well, their finding was we should do it under international law, and they refer to the approach particularly employed in the ALSI articles relevant to state responsibility. And still, that can be helpful. We can look at it. Another, I think, relevant point would be interaction with states, with home states' position taken, for instance, in some enforcement proceedings, where it purports to plead sovereign immunity with respect to assets belonging to state-owned entity. In that case, if the state-owned entity, the very same one, then tries to find a standing as an investor under BAT, that could also create a problem, of course, because arguably you can't have it both, the state immunity and being an investor under BAT. Finally, also, if that particular investor or acted as a state, or some way it was determined that it should be regarded as a state in the context of state responsibility as such, of course, it could be a strong argument pointing to, that this test and this finding under different tests would be relevant when we are within BAT treaty or BAT arbitration. Yeah, those are just general consideration. I know that I didn't cover, the specific elements, whether, we should distinguish governmental authority, like functional test, but for me, still at theory level, they're a bit artificially distinguished. So I would just leave it to my colleagues to comment. Thank you.
Thank you, Olga. I don't think there's no right or wrong answer, because if we take a step back, we are working to interpret a statement that Mr. Brockes made in a course, in a Hague Academy course of international law in 1972. This is when he devised the Brockes test. It's a statement really that we're trying to interpret in light of the ICSID Convention. And if you are dealing with a tribunal that adopts a systemic approach of international law, i.e. it views international law as one cohesive body and international investment law as part of it, then of course it makes sense to refer to other standards and to seek inspiration from conventions, from rules, from treaties that are distinct from the ICSID Convention context. And so it's a question really of first and foremost facts, I think, because as Professor Feldman has said, someone who is wary of applying the ICSID Convention faithfully is merely seeking to ensure that the respondent, the claimant, is not the home state. That this is a dispute between an investor engaging in investment activity with a host state. Full stop. I guess that's what Brockes was driving at as well. We don't know what he thought, but we do know from the history of the convention, from the drafting of the convention at that time, which was the Cold War era, that we wanted to depoliticize the signatories to the convention wanted to depoliticize the process for resolving investment disputes. As Yury said, there was a policy decision to move away from diplomatic protection because it has undertones and did in fact lead in many instances as recent as this century to armed conflict. And so there was also a decolonization atmosphere. States were being decolonized, new states were being created, and so the signatories also wanted to get rid of that colonial and colonized dynamic. They wanted a more neutral process for the resolution of investment disputes. They wanted to get rid of gunboat diplomacy. Effectively, they wanted to get rid of colonialism. And so that's the policy goal of the ICSID Convention, and that's what everyone is concerned with. Now, the difficulty is, and this sort of goes back to the context that we're dealing with, the Cold War era had its challenges, but today we also have challenges with state-owned entities. Many people for a while thought that this debate would be irrelevant today. I see a comment from Todd Weiler in the chat about when FET was first mentioned, it was mentioned in the context of SOEs having regulatory powers and monopoly powers. The ICSID Convention was passed at a time when the context was the Cold War, and half of the world basically had a controlled economy and a regulated economy and had state-owned entities play a dominant role in a politicized manner. Today, actually, the state still plays a significant role. And when I first wrote about the subject in 2015, for example, we saw that $4 trillion were being invested and managed by sovereign wealth funds. Today, that figure in just 6 years is 7 trillion. And so we all know, anyone reading the press every day knows that there are concerns that are raised as a result of investments, cross-border investments in certain sectors, in AI, in technology, in telecommunications. You've read about them. You've read about the concerns arising from the investments by, for example, Huawei in many European countries. Not only that, not only in these high-end sectors, in sports. So anyone watching football will know that the recent acquisition by the sovereign wealth fund of Saudi Arabia of Newcastle United has stirred a lot of controversy. Why? Because, and again, it goes back to a very important point that Professor Feldman has mentioned: government ends. Some people are viewing that investment as achieving Saudi government ends, as achieving what others have called sports washing. So it's effectively a foreign policy goal. It has nothing to do with the sports. That's what some argue, those who are against that investment. Others are saying this is simply an investment into a football club. There's nothing controversial about it. If tomorrow there were to be a dispute between the public investment funds, so the sovereign wealth fund of Saudi Arabia, arising from its investment in Newcastle, that sovereign wealth fund shouldn't be treated any differently than any other private investor in any other English football club. So you see that the debate is still relevant today, and the question hasn't been resolved. And so to answer your question about which standards to use or how do we interpret the test, I think all tools are at one's disposal to reach to the true policy goal of the convention, to achieve that.
As we're talking about these goals, we've discussed a fair bit already about governmental authority and what it might mean. But as we heard in the initial remarks, there seems to be an inherent dissonance of some kind, because as we know, governmental authority under customary principles of jurisdiction would be traditionally exercised within the domestic national limits of a state, whereas in making cross-border investments, what we seem to be suggesting is that state-owned enterprises somehow exercise that government authority extraterritorially. So is there really an inherent contradiction in suggesting that an SOE investor may be exercising governmental authority in pursuit of its investments? I know that Mark already addressed this very briefly in his introductory comments, but maybe you want to touch about this and elaborate about this a little more.
Sure, I think it's a great issue. And often the discussion of governmental function, I think what is sometimes missing from the discussion is the important element of authority that is delegated, right? So it is your own government that is delegating authority to you. And I think in the jurisprudence, when applying governmental function, I think that point has been lost a bit, that the analysis has been, well, the construction of an airport terminal or the operation of an airport terminal, is that a government function? Is that a commercial function? And what I would like to see more of in the jurisprudence is engaging with the question of, has this SOE's home state delegated some form of governmental authority to it? And I think if we look at the issue that way, then, as you say, this idea of a home state delegating authority that is to be exercised in the host state, that just seems odd, right? It's not clear how, if we're focused on this idea of delegation, how would that authority be delegated across borders?
I think just to follow up on this point from Mark, I think in theory, when you look into this, suppose that delegation is possible in theory, and it can be even properly documented. But it's, I think, important thing, what authority we talk about, because if it's delegation to exercise home state's authority at the territory of the host state, so that basically you don't have authority. You don't have the police powers there, at least legitimately. You don't have to. There may be something like the home state would be dictating, for example, the pricing policy for its state-owned enterprise which built up the airport, and sometimes I wouldn't be surprised that sometimes that may be actually against the interests, the commercial interests of the specific investor. But the question, and that's also the question I was asking myself when I was reading a few days ago an article by Mark, which he wrote, I think, 5 or 6 years ago. If we speak about this and motivations, or the purpose of that investment made by a state-owned enterprise at the territory of the host state, why do we actually care about that of the purposes behind? Because there may be multiple purposes. And when you have the state-owned or state-controlled company investing abroad, usually there will be an interplay of purposes. And it's not always easy to say which one is dominant, which one is not. I think what's important, speaking for myself, what's important, I think, is the ultimate kind of outcome. The investment was made, the airport, for example, was built up. The host state has the means to influence the pricing policy in the airport, because an airport is usually a natural monopoly in specific kind of a place, because it's a very important piece of infrastructure. So the host state has the means to influence that. And even if the host state is concerned about the exercising of the home state's authority in its own kind of a territory, or is concerned about the inner mind behind the rationale behind that investment, well, a difficult but simple answer usually is just say no to the investment. So you can assess some of those risks up front. And I would say that many developed states, and I think even kind of developing states, they have the local legislation in place, special procedures for clearance of so-called like foreign investments. So Russia has it, the United States has it, I think some of the European jurisdictions has it. So basically, if you have a foreign investor making an investment at the home state's territory, there will be some clearance procedure. And I would say that those and those pieces of legislation, they do distinguish between the purely private investors and state control. For example, the Russian legislation does make it a distinction, and it is, I think, an important rule under Russian law that foreign state-controlled enterprises, for example, they cannot acquire control over the Russian strategic enterprises. And I'm aware of like kind of a local litigations around those issues that they've never been brought up, as far as I know, to investor-state arbitrations. But going back to the point is, why do we then care about the motivation? Because it could be complicated. If there is a dispute, we already kind of in investment arbitration case, to find out those motivations behind the investment or specific decisions taken by the investor after it already made an investment. It's difficult to find out. You need to implement those document production procedures, and those are usually quite intrusive. And maybe to go again to one of the comments from Mark is that the tribunals are usually not called to resolve the state-to-state disputes. So what the tribunals are should try to avoid is that the home state is kind of being behind the scenes and driving the process as for the claimant, for the state-controlled investor. That's probably right, but then the question is, the tribunal doesn't have jurisdiction against the home state. It has jurisdiction as against the claimant, because the claimant effectively submitted to the jurisdiction of the tribunal, and the claimant is asking to resolve the specific dispute as between the claimant, which is probably kind of it may be in theory possible that it is home state who is actually using that vehicle of its enterprise. But what the idea is that if the tribunal refuses its jurisdiction in such type of dispute, it basically escalates it back to the diplomatic routes. The tribunal would need to say, you know what, I think it's really a state to state. The two states should deal with that. Again, I don't have a clear answer to that. I'm a bit skeptical that the tribunal should refuse its jurisdiction in such type of circumstances, because it still has a claimant coming in its own right and bringing this claim to the tribunal. But I do understand, I can understand the hesitation which the tribunal may have if it really sees, if the members of the tribunal, they really see the home state driving the process behind the scenes of the claimant.
Maybe if I can test this, Yury. And,
yeah, of course.
I mean, it's on the first side. I think it sounds good, because you say the whole state, it can control it. It has investment control. It can see who is investing. It can make a due diligence into the investor. I think that is fair. But speaking about now the purpose. And what is behind the investment? I mean, this is something that is often not visible at the time of investing, or a government might change, and maybe it was not visible to the previous government, maybe on purpose not visible. So what do we do with such situations? And I mean, you mentioned countries like Russia or large countries, and I'm sure countries like Russia or like Germany or the US will be perfectly able to exercise this investment control, but I'm not sure that smaller and less powerful countries that depend more on foreign investment might be able to do so. And one more point, because you said, how should we do it? Document production, it's very burdensome to find out the purpose. I fully agree, but it's only the fact that it is burdensome is this excuse to actually not perform this task and only focus on control. And I was also asking myself in the course of this preparation, even if you would have this document production, could then the state-owned enterprise rely on the IBA rules on taking that evidence and the exception in Article 9.2, which gives exception for the production of documents for grounds of special political or institutional sensitivity. So would it be possible to refuse production of evidence based on this exception, but at the same time say, I still want the tribunal to exercise jurisdiction?
Filip, may I add one point?
Of course.
Just on motivation, and Yury, it's very good that you bring up motivation. And I just wanted to add, because I think it goes back to this relationship between the Brockes factors and customary rules on attribution. That in my view, the Brockes writings, Brockes gave us the factors, but only the standards themselves without any content. And so in my view, when we're looking for content, that customary international law is the natural place to look. And if we look to ILC Article 5, motivation, purpose is relevant. Now, I take the point that as a matter of evidence, it is certainly challenging as an evidentiary matter. But nevertheless, under customary law, purpose and motivation is relevant. And so in my view, to match the customary approach, we should at least acknowledge, while acknowledging the evidentiary challenges, we should at the same time acknowledge that purpose and motivation should at least be considered, should at least be relevant as part of the analysis.
So some of the very, sorry.
If I may come back to the initial point, actually, whether we can find practical examples of the state like delegating its governmental authority to state-owned company for the purpose of commercial activities, for instance, abroad, as well for the purpose of governmental activities abroad, but as an investment. Actually, I have a very specific example from my own practice where we considered whether that state-owned entity can be an investor under BAT. So there was a framework agreement, and I just want to share it, again, to test the theory. There was a framework agreement between two states, one of which was Russia. And then in that framework agreement, both states committed actually to launch a particular project, like production plant in one of the states. And then an agency of one state executed basically a contract with business persons of another state and launched that project. So then you have, an interstate will clearly articulated in the framework agreement, and you don't need even document production for that, and a contract between a state-owned entity and basically another company in the host state to implement that agreement and to make an investment for the purpose of building this production plant. So we were considering whether in that case we can go to investment arbitration and say that the state-owned entity is an investor. And the issue we had was particularly that one, that basically that entity was provided with this governmental authority by the state. And whether we can say that eventual commercial activities in the host state, they actually justify, the standing. That was just to share my experience, I guess, and to say that we can find those examples in practice. Yes, and that it's not just a theoretical issue.
Yeah, if I may build on that that example that Olga has just mentioned, I think the difficulty can be with the term authority, governmental authority. If that term, and if that term is interpreted as governmental ends, then obviously you can see many more examples where an investment, a cross-border investment by an SOE serves government ends. These could be, for example, foreign policy ends. They could be, and we have real-life concrete examples of that. You have the Al Jazeera versus Egypt case. And in that case, Egypt's position is Al Jazeera, which is a media network, a television channel, is not really an investor like any other investor. What it's doing is it's promoting the state of Qatar's foreign policy goals in Egypt and elsewhere. And so that investment, they argue, wouldn't be protected. And the interesting thing here is there's an interplay between jurisdiction and the merits. And let me tell you why. Because if the home state considers that activity to be illegal, for example, because it results in a breach of its laws, its criminal law, it results in a breach of its anti-terrorism law, for example, the investor is promoting terrorism according to the home state, then you can expect the state to either raise this issue as part of the application of the broker's test, or to raise it on the merits and say that activity by a foreign government, that interference in our market, that interference in our home state is illegal, and therefore the investor shouldn't be entitled to BIT protection on the merits. There shouldn't be a breach of any treaty standard because we have taken action against the investor to remedy their violation of our laws. And so they're not entitled to any of the protections provided for in the BIT. So there are concrete examples, and as I said, we will be seeing more examples because the Cold War era, yes, is gone, but the states remain, the community of states remains active and remains involved in cross-border investment. And we do know that it is used sometimes to meet governmental ends, but not necessarily to fulfill governmental authority. And so the question is, again, whether the two mean the same thing or not.
I think just picking up of the example which Farouk just made, I think it's a helpful one. I would just go back to the point where we started. Really, it's the bilateral or multilateral investment protection treaty, which is the source for the analysis. Because instead of the Roche's test, what I would be thinking is like, okay, you need to protect the investment, which is made in accordance with the legislation of the host state, which is a quite common phrase we see in bilateral investment treaties. So the investment made in accordance with the host state legislation. And taking the Al Jazeera example and just modifying a little bit. Suppose they established a subsidiary in Egypt, and given that the purpose of Al Jazeera and its subsidiary is to promote the foreign policy of Qatar, for example, suppose Egypt has a legislation which requires them to register them as I don't know, foreign lobbyist or foreign agent. We, for example, have such a legislation in Russia. So it basically requires you to label yourself in a certain way, but you fail to do so. I mean, when they established the company, a local one in Egypt, then you have a breach. And then it's a jurisdictional defense, which the states can raise if they, for example, then take away, or they take away the license from that, the broadcasting license from that local subsidiary. But but then you have that in the investment protection treaty, because you are not supposed to be protected because the investment you made in the first place, you made in breach of our local legislation. So that's how but it's not like, okay, we need to look at the Brochus test, we need to look at the customary international law. You look at the specific treaty and apply it in a specific situation. So that's where I think it's same. So basically, there could be examples like that in many things. For example, I was thinking about the extreme cases as to if we look at the exercise of foreign power or some sovereign authority by a purely private company in a host state jurisdiction, and you don't have the structural test usually, but suppose like it's a private security company protecting some business organizations which travel, to some heated jurisdictions, heated countries. So that security company its primary task would be to protect the businessman coming from its home state. It will build up the infrastructure. So it's not controlled or owned by the foreign state, but at the same time, it exercises its power of protecting its own nationals, of the home state's nationals, at the territory of the host state. The question mark, if that security company builds up some pieces of infrastructure, are those protected? Because in theory, they should be, unless there is some specific breach of the when they were making investment, it is illegal. But the fact that the purpose of that company is to kind of effectively delegation of the home state's police authority to protect its own citizens, I think in theory that security company should be also protected as an investor and the investments it made in the host state, unless there is a breach, unless you can show that the investments made by that private security company doesn't fit into the definitions which you would normally see in the bilateral or multilateral investment protection treaty. Sorry if this example is a little bit messy. So, but I'm welcome others to comment on it.
Can I jump in just on Yury and Farouk's point quickly, if that's okay? So Farouk, it's a great example you raise that, let's say you have an SOE in the host state that's advancing the goals of its home state, of its home government. And you can have legitimate policy concerns about that. But I think to address that in a treaty, it would need to be lex specialis in the treaty, right? Because if you look to the customary rule, if you look to ILC Article 5, the language of ILC Article 5 is empowered by the law of the state, right? And if we just have an example of an SOE that is advancing state interests, to me, that is different from an SOE that is actually empowered by, that the home state has actually delegated authority. And so again, I think for policymakers, again, it can be a legitimate concern. If policymakers are focused on the issue of SOEs advancing home state governmental interests, then I think the policy response is through treaty practice, treaty rules, lex specialis, rather than relying on the customary attribution rules.
So many points, difficult to really tie it into, but I'll try to kind of transition and sort of maybe to attempt, if it's even possible, to wrap up on this governmental authority and control test before we probably move into the issues of evidence and more practical questions. Filip, Farouk, Mark, Yury, I believe also mentioned, and just now, the issues of purpose of the investment and how it ties into the governmental authority. Mark was just talking about how, an entity really should be endowed with such authority. In this context, is it possible, and could you elucidate, and if it's possible, to distinguish between this governmental authority and the agent of the government? So the agency, which could be found, again, in the Brockes test or in, Articles 5 and 8 of Articles on State Responsibility, because the line seems to be blurry also, with Farouk's example.
Right, so if I may, on that point, there's language from the commentary to ILC Article 8, and the language says a state was using its power to control specifically in order to achieve a particular result. And to me, that language is very important because I read that language as the result, it might be a commercial end, it might be a governmental end. And to me, what matters for the control analysis is just that the state had some specific goal in mind. And the state was looking to its agent to achieve that goal. And so what I've seen in BUCG, what I've seen in CSOB, is there will be discussion of control. And then when discussing control, there will also be discussion of government function. And this goes back to the point that I made initially, that I see those as separate concepts. And when we're analyzing control, the analysis should be on control. And we should not be bringing in the commercial versus governmental distinction. Rather, the analysis simply should be, in this specific instance, was the state looking to achieve a particular end and looking to use this agent to achieve that end?
Yeah, no, a very good point, and definitely very difficult to reconcile, and also the rules on attribution. But this is definitely clearer now, I believe. Vishakha, would you like to take the lead and proceed with the questions related to evidence? Unless, of course, speakers would like to dwell a little bit more on agency and governmental authority.
Right. If that's not the case, perhaps one point that I'd like to bring the discussion back to is what Olga mentioned about relevance that the host state's home state structure and domestic landscape might have in characterizing an SOE as an investor. And I think both Filip and Yury touched upon the evidentiary challenges that might be faced by practitioners when attempting to characterize an enterprise as a state-owned enterprise. There's also a lot of background information, I think, that is often taken into account, such as what is the sort of political landscape of the home state, what is its economic system like, is it a market economy, is it a state-centered economy? So could you speak to us about what kind of evidentiary challenges become relevant in the context of characterizing enterprises as state-owned enterprises in practice? Maybe Filip, you'd like to start us off on that point.
Yeah, I'm very happy to start on that, and I think I mentioned it previously a little bit, and I think when it comes to control, it is. If you think first of shareholding, it's quite easy to ascertain what the shareholding is, and also if it comes to officers of the state-owned enterprise and their role in the home state's government, I think this is a quite easy one, and the cases that we see also often focus on those two factors to determine control. I think where it really gets much more tricky is when it comes to the purpose, and here I think it can get really difficult to get the right evidence, because this control will usually not be that apparent, such as shareholding or such as officers, corporate officers, and so I think, or whatever else is said in the agreements, because of course it's not only about the officers and the shareholding, but there can be a number of other factors like voting rights, appointing rights, and so on. But when it comes to the purpose, I think it gets really tricky, and the question is whether this evidence is available at all, and if it is, whether it will be accessible and how. And I think Yury mentioned document production, but I think everyone here was running document production, these kinds of scenarios where state interests are at stake. It turns out to be extremely daunting exercise to get this, and it's if not an impossible, almost impossible exercise. So I think this really comes to a question of evidence in the end.
I'm not sure if Yury or Olga.
If I may add, from my experience in practice, the most difficult one of the most difficult aspects to elucidate and to substantiate into evidence, of course, is governmental instructions. It's any instructions that you as a party suspect exist or are sure that they exist, but it's impossible to sort of prove sometimes because you're not privy to governmental discussions. You can't have access to them very often, and you sort of, if I may simplify, you'll reach two hurdles. The first is very often these deliberations or instructions will be, as a matter of whole state law, will be secret or will be confidential or will not be accessible in the public domain. They'll be privileged. And the second is when, which is a point that Filip mentioned, when one seeks to obtain them in document production, there are various ways in which the state can say these are sensitive, these are privileged, and deny production. So I guess as a practitioner, you have to do an intensive factual investigation and gather as many documents as possible, and then use the documents that you have as hooks, as leads to further document requests, and dig deeper that way, and push the other side as much as possible to disclose based on what you already have, based on the exhibits that are on the record already. Use that as a basis for further requests, and then if you succeed in convincing the tribunal that these documents are relevant and material, and you get an order from the tribunal and nothing is produced, then you ask the tribunal to draw adverse inferences. But it is quite challenging. It's one of the biggest challenges in litigating against states. Conversely, if you are acting for a state, you have challenges of your own, because very often you will find that, certainly that's consistent with my experience representing states, that states are not necessarily litigious. They're not necessarily operating with a dispute on their mind or with a potential dispute on their mind down the line. They are essentially in the business of government. They're not in the business of claim management, and certainly not of claim prevention. So the record can be sometimes the record of state deliberations or of state correspondence, or of the things that a state did or did not do, can sometimes be patchy, because that's not what their business is. They're not law firms. This is not what they usually do. They have other things to worry about. So there are challenges on both ends, depending on who you represent, and they're all very interesting. And again, we tend to think about them when we're in the arbitration. The interesting thing to do would be to think about them before. And so if you're advising either side, you have to bring it to the radar as a practitioner, as their advisor. You have to bring these issues to the radar of your client, again, be it an investor or a state, very, very early on, and tell them, have a proper paper trail. If you're discussing things that are privileged, mark them as privileged, etc., etc.
Just to build on Farouk's point about states' challenges, and so normally you would have actually different branches of the state, right, involving in initial activities that led to the dispute, and the branch would be in charge of this dispute handling. And when talking about document production, etc., even internally, there may be a big, lack of interaction between different just branches. So what I saw when working for the state, lawyers dealing against states, they really tend to treat the state as any other party, as basically a company. which is of course not true in reality in terms of, I mean, document production and anything else, and internal interaction. So there are many additional challenges and I think specifics which you need to treat differently from other parties, non-state parties. Yes, that's for evidence difficulty. And coming back, Vishakha, to your initial point, I think it's very, I mean, the question of evidence and which evidence you can employ and which you should employ, of course, it's very case specific. And generally what you would be looking in that case is finding any materials and information, right, pointing to a separate legal personality of the state entity. And it would cover normally just at very high level, a regulatory side, a functional one, and everything that relates to this particular transaction and this particular nature of investment.
Yeah, if I may just follow up on comments from Farouk on the document production, I think whether you act for the claimant or for the respondent, what you need to remember is that it is a two-sided road. So whatever the respondent is requesting from the claimant on certain and employs certain rationale to show that the evidence the respondent is seeking is material and to the resolution of dispute, basically the same arguments will be often available to the claimant. And I've seen that actually happening in practice in my experience. But apart from, so specifically as to when you don't get the documents, but for example, in the if, and again, it's a hypothetical, if you have, for example, a CEO or a deputy CEO of a claimant, which is a state-controlled entity, and he appears as a witness, voluntarily tendered by the claimant, a possibility for the respondent's counsel to explore is in the cross-examination. So if the rules are not very strict, that you don't expect, there are broader scope of questions you can ask to other party's witness. So usually we may want to see and whether he or other members of the management board of the company were basically instructed directly by the people from the home state's government. So it's another source of information and evidence which could be employed. And rarely, if the issues are really central, I've seen examples when the members of the tribunal would even call witnesses, some really prominent and high-level figures, to appear in the proceedings, and those sometimes they do appear, so they not necessarily would escape, even though neither of the parties may be able to procure the appearance of this or that witness.
Can I ask a question? I mean, to this round. I mean, because we are speaking here about document production against the state-owned entity against the claimant, should the state-owned entity be allowed to invoke the exception of Article 9 IBA rules, the grounds of specific political or institutional sensitivity? Because what it wants to say here as a claimant is actually that it is acting in its commercial capacity. So should the state-owned entity be allowed to invoke this exception at all, or not? And what are you actually looking at? I mean, you're looking basically at communications between the state-owned entity and the state to make sure, what Marek said before, that the state is not part of the table on claimant side.
I think the answer is a tactical. In theory, while those kind of objections to the document production, which are specified in Article 9, they're not drafted in a way that those apply even to commercial arbitration. That's what I'm saying. So in theory, a state-owned claimant can easily invoke that in principle, because those are also available. Whether to make such an objection to the document production request is an important judgment call to be made by the claimant with the proper advice by its counsel. Maybe sometimes it's just basically, if you want to emphasize that it's really a commercial dispute, maybe easier to produce what is requested if there is really nothing in there. And it's one thing. And second, unlike it's also related question of, so the documents which are in possession, custody, of control of the party. So the documents which would usually be available to the claimant would be limited to those what the claimant has. So for example, if there is a meeting in the government somewhere and there is a, I don't know, the minutes of that meeting, which is not public, which is secret, usually the claimant would not have those unless he actually received, unless the company actually received those by one way or another. It's somewhat a bit different for the respondent state, because if it's a kind of a joint venture dispute and you have state-controlled companies on both sides, the respondent state may be in a slightly more difficult position to argue that it cannot obtain documents from its own subsidiary, which is not party to the proceedings, but at the same time, the documents which are sometimes which are available to the respondent may, in certain circumstances, capture the documents which are stored or belong to its own state control enterprise. But again, as I said, to your specific question, it's an important judgment call.
Perhaps that is an auspicious note to wrap up what has been an immensely interesting discussion. I'm sure all of us could perhaps launch several more questions at you and hear you talk about them at day's end. I think my key takeaway from this discussion has been that given the sort of peculiarities and difficulties associated with existing tests and the varied interpretations and ways at which you can look at treaty silence, maybe treaty practice needs to involve to have specific disciplines on state-owned enterprises, and perhaps that is something states should and will consider when they launch onto new processes of new generation treaties. With that, I would simply like to thank this extremely incredible panel for all of their very, very valuable inputs. It has been a pleasure listening to your thoughts from varied perspectives. And I'll hand over to representatives from the RAA, Alexandra, and I believe we have Paulina with us as well to sort of conclude the event with some remarks.
Sorry, Victoria, Paulina, could you?
Yes, I'm here. Sorry. Sorry. I can see whether Paulina is here. Can you see the same that the sound is doubling or something is, or it's only in my Zoom? I think it should be okay. So sorry for this technical problems. On behalf of St. Petersburg University, as Paulina is not here with us at this panel, and on behalf of Russian Arbitration Association, we are extremely happy to see all these wonderful and excellent speakers and moderators who devoted their time, experience, questions, their joy, their interest in the topics that we have just discussed. And I really hope that the participants will find this useful. And I will not spend any more minutes of your time. I will also say that we'll also have the second panel devoted to quantum issues. Please stay tuned and let's wait for the second panel of speakers. Thank you very much for your attention.
Thank you.
Thank you. Thank you, everyone.
Thank you.
Thanks, everyone.
Thank you, everyone.
Bye.
Hello.
Hello.
Is your internet connection working better today, I hope?
I think so, yes. And I'm hoping it doesn't betray me over the course of the next couple of hours. Thanks for joining us. I think we have everyone here. We're still waiting for Diana to join, I think.
David, I made a different call on the tie. Not really sure what our Zoom's webinar etiquette is. I'd be happy to run upstairs and grab one if you think I should.
I don't think so either.
Good, I think good afternoon to all of you.
Good afternoon, everyone.
Hi, hello.
Hi.
Shall we wait a couple more minutes for everyone to join in and then maybe to start?
Sure.
Yeah, I think we're still waiting on our final
Okay.
panelist.
It is okay with, okay.
Are we running on time today?
I believe so. We still have 3 minutes to go. And we're still hoping Diana makes it on call in those next 3 minutes. I think we should be able to start on time. Hello, everyone. I believe
So for the sake so for the sake of being touching to them, I'll make a short moment to start with some welcoming remarks. First of all, my name is Tsutieva, and I'm heading the International Moot Court program at St. Petersburg University. Welcome to all of you here from our beautiful city. Even though it is online, we strive to make this experience even more valuable for you every year. And I still do hope that next year I will get a chance to say these words in front of the audience live, maybe in front of some of you here at St. Petersburg University. First, I would like to say thank you to the Russian Arbitration Association for putting all of this together and for helping us to achieve excellence in the event. I believe the first panel went great and the discussion was lively, and that was the idea behind us organizing this conference. We wanted to make it interesting not only to the FDI participants, but also for the practitioners in the field. And to the FDI participants, I wish good luck, and may you take some of the advice, some of the opinions from this conference to your rounds tomorrow. And to the participants, please do enjoy and actively partake in what our wonderful moderators and our wonderful speakers have you. Well, maybe with this being said, I would only like to add to those of you who are participating in the rounds tomorrow to make sure that you remember to have fun, because this is the fun part. Your preparation is almost done at this point. So the more fun you have, the more fun the arbitrators have, the more the higher grades you get. With this being said, I do welcome you again to the e-conference and to the 5th St. Petersburg FDI Pre-Moot. And without further ado, I give the floor to our wonderful ladies, Vishakha and Aglaya. Please go on.
Thanks so much, Felina, for those very, very kind words. And welcome, everyone. And thank you so much for joining us today. We're hoping that you're looking forward to the discussion that we're going to have today on issues of compensation in investment arbitration with this incredible panel that the RAA has assembled for us today. I'm delighted to be co-moderating this session with Aglaya, with whom I had the pleasure of co-authoring the 2021 FDI case. And irrespective of whether you're participating in the moot or not, we think you're going to enjoy and take away a lot from the discussion and the perspectives that our panelists will offer today on treaty and customary standards of compensation in international investment law. Aglaya, perhaps you want to add a few opening words?
Yes, absolutely. Hello, everyone. And indeed, it is an honor for me to be co-moderating such an esteemed, prominent panel today with Vishakha. So yes, I'm just hoping that today's discussion also is going to shed some light on, various compensation-related issues, among which are, perhaps questions that arise in the context of non-expropriatory breaches. So with that in mind, Vishakha, I could start by introducing some of the speakers. And then, so it is my pleasure to introduce the first speaker, Ms. Diana Tsutieva. I hope I pronounced this correctly, and apologize if not. So Diana is a counsel at Foley Hogg in Washington, D.C. At the Department of International Litigation and Arbitration. Diana is trilingual. She speaks Russian, English, and French, and she is dual qualified in the US and France. So she focuses on international dispute resolution and has extensive experience in complex international investment arbitration matters, public international law matters, as well as international commercial arbitration matters. Diana currently represents the Republic of Ecuador in the damages phase of a very high profile proceedings, investment arbitration proceedings involving the BIT claims. that involved environmental litigation in Ecuador against Chevron, so that longstanding saga. She's also counsel to Bangladesh and its state entities, such as Petrobangla, and in a dispute before the ICSID convention, the ICSID tribunal, having successfully obtained a decision on liability of the claimant. She is now working on the recovery of damages. And the next speaker I have the honor of introducing is David Khachvani, who is a senior associate at Levy Kohler in Geneva. He specializes in international commercial arbitration and investment arbitration. And over the past 10 years, he has acted as counsel, arbitrator, and arbitral secretary in over 25 high-profile arbitrations involving various industries and under major arbitral rules. So he's qualified to practice in Georgia and works on disputes that are governed by different national laws, such as the English, Russian, and the Turkish laws, as well as under public international law. David holds a doctoral degree from the University of Geneva Law School, as well as an LLM from MITS. So Vishakha, I'll leave it now to you to introduce other speakers.
Thank you. We are also joined today by Dr. Martins Paparinskis, who is an associate professor in public international law at the University College London in the United Kingdom. In addition to this, he is also a member of the Permanent Court of Arbitration, the OSCE Court of Conciliation and Arbitration, and the ICSID Panel of Arbitrators and Conciliators. Presently, he has been co-nominated by 3 Baltic states for next month's election to the United Nations International Law Commission. He has widely published on issues of public international law with a focus on international investment law, and is often cited by investment tribunals, including one in the latest case of Lyon versus Mexico. And closing in our very star-studded panel is Mr. Mark Friedman, a litigation partner and co-chair at Debevoise and Plimpton's International Dispute Resolution Group. His practice concentrates on international arbitration and litigation, and he has acted as counsel or arbitrator under various institutional arbitration rules, including but not limited to the ICC, the LCIA, UNCITRAL, and ICSID. He has also formerly been the vice president of the ICC Court of Arbitration, the chair of the International Bar Association's Arbitration Committee, and a member of the Court of the London Chamber of International Arbitration, amongst various other stellar appointments. Thank you so much to each and every one of you for taking the time and joining us today on this very interesting topic, and for agreeing to speak with us on these issues. Aglaya, over to you.
Thanks so much, Vishakha. So starting with the first question, that in the context of states' increased tendency to define more, so to speak, in the treaties, the standards for compensation, could you talk a little bit about the differences between the fair market value and the market value standards, and also in that how they are similar or different from the full reparation principle? And if I also may add to that, how the notion of the fact that the state should not benefit from its internationally wrongful acts in the context of compensation play into that. I believe, Mark, you'd like to take the lead on that one.
Sure. Thank you. Thank you very much for inviting me to participate in this tremendous panel and on a topic, namely compensation and damages in international investment arbitration, that I've actually been interested in and litigating about for more than 20 years. The first question focuses kind of on the difference between market value and fair market value, and sort of raises the question, can you have a market value that's unfair? Is there a difference between those as standards? As a practical matter in investment arbitration, the answer has tended to be no. Most tribunals have not found there to be much of a difference between them, nor have they tended to find differences to a great extent amongst different articulations of standards that you might find in treaties. We'll come back to that more, I think, during further comments in this discussion. But just sticking with market value versus fair market value, at least the practice of tribunals in investment law has not been to draw distinctions between them. Now, if you asked economists or valuators, you might come up with a slightly different answer. again, their practice and guidance is not uniform. But some people might say that that market value is the actual value at which an asset would trade at a particular date. Whereas fair market value has a bunch of assumptions laid over that transaction, and it becomes, instead of a more like the actual transaction that would take place, a hypothetical transaction that makes assumptions about good knowledge on both sides, lack of coercion, arm's length, third-party transaction, and that sort of thing. Now, not all valuators or economists agree that there is a distinction, and some valuation standards equate them in any event. But even if you assumed that there could be that difference, that is, that the fair market value assumes a kind of more perfect world of information than a hypothetical transaction, and market value looks at what was actually going on in the market, would there be a difference in investment arbitration? And there you can again get to the answer that there might not be much of a difference in most cases, because Aglaya, what you mentioned, that is that you then have to layer on in investment arbitration some rules of law, including that the state can't benefit from its own unlawful conduct. So you could imagine a situation where there was a theoretical difference in that, let's say, in June 1st of some year, the state took over an asset, and but they'd announced they were going to do it a week before. So if you looked at the immediately prior to, you'd be in the period where the state had already announced it was going to. That would obviously depress the market value. Nobody's going to come in and pay actual money for that. But would you nevertheless think about it as a hypothetical transaction closer to the fair market value standard, because you then layer on the rule that the state shouldn't benefit from its own unlawful conduct? And that rule makes a lot of sense, because you wouldn't want a situation where states could get away with freely expropriating or committing other breaches of international law simply by talking down the value of the investment, by saying, we're now going to behave illegally. We're going to do it in a month. And we're going to benefit from the reduced value of the investment. We're going to reduce our damages by telling you we're going to behave illegally a month before. That I don't think many people would think that makes much sense normatively. And consequently, there is a certain logic to tribunals having largely come to the conclusion in decided cases so far that there's not a real difference between market value and fair market value in practice in investment arbitration.
Perhaps some of our other panelists would like to comment on these introductory remarks, and especially in the context of how both or each of these standards relate to what we know as the customary standard of full reparation.
Yeah. First of all, I join Mark in congratulating the organizers on putting this wonderful event together, and I'm happy to be here, and thank you for the invitation. I was just wondering, listening to Mark's remarks about the fair market value versus market value, whether hypothetically, although I understand in the case law that hasn't been the case yet, the addition of the fair standard in the fair market value would open sort of a way for the investor to challenge the fairness of the market regulations, or more general market regulations that the state has in place, which sort of restrict the marketability of the assets that is in question. So, for instance, there have been cases where an issue was the restrictions that are placed on marketability of certain types of items, such as agricultural lands, for instance, to foreigners. And if that kind of limitation is imposed by the state, although it is within its regulatory powers to do so, and generally recognized like this, whether the inclusion in the treaty of the fair market value standard would open a way for the investor to argue that if that regulation hasn't been in place, the market would be fairer and the asset would have sold at a higher rate than it was sold in a specific circumstance, and thus claim the increased compensation.
Yeah, David, that's an interesting question. I I'm not aware, I stand to be corrected, but I'm not aware of tribunals having read that much into fair in fair market value. I think that what they've looked at is the conduct of the participants in the transaction, which tend not to be the state necessarily. It's a hypothetical buyer and a hypothetical seller transacting regarding that particular asset. One of the ways that so it doesn't really kind of change all of the market circumstances, but those other rules of public international law, or that like the state can't benefit from its own wrongdoing, may come into play. Some of those issues have been litigated pretty heavily in some of the Venezuela cases, and tribunals have taken different views actually about how much of the sort of market interference or distortion or regulation, depending on how you look at it, by Venezuela of those markets, like the restrictions on export, for example. Are those also breaches of, but they're analyzed not in terms, I think, of the sort of almost economic standard of fair market value, but whether those restrictions are also illegal state conduct that needs to be assumed away in conducting whatever the valuation analysis is. But it's an interesting argument. I don't know that you'd get economists to push it. And so as a practical matter, when you're litigating, your valuation experts in a real case take you so far, and they can say, here's what, our standards, our professional standards tell us fair market value is. But I don't think the economist professional standards allow them to quite so radically change external market conditions, whereas they can regulate the amount of information or quality of information between the hypothetical buyer and the hypothetical seller.
The reason I posed this was that the way I understand, obviously the moot participants know much more about the moot case, but the way I understood that part of the measures that are at issue was precisely the state's measures that sort of impose certain restrictions on the marketability of the shares in question. So it was not really free market transaction in the sense that the investor was not free to sell it to a private buyer. So that could probably, as you say, Mark, would be part of the measures that are impugned as contrary to the FET standard or the expropriation standard, and then would be assumed away from the counterfactual scenario. That would be probably, that would not require necessarily the reliance on the fair market value language.
Right. And I think that a way to get to that is, Aglaya, you also asked, how does it relate to the full reparation standard, fair market value? I mean, I think fair market value or any valuation standard may be a way of achieving the reparation standard in a particular case. I think the reparation standard as being the general standard at which the tribunal should be aiming, because that's what the legal dimension is. And then there may be different ways of applying it. And those may vary from case to case, but often in investment arbitration, the circumstances are such that fair market value is a reasonable proxy for full reparation, where you can't give actual restitution, but you have to give the value that a restitution in kind would bear, fair market value will do it. And David, that's, I think, where tribunals also can draw some inspiration about then, well, how do we then think about what the situation would have been but for the illegal acts? And you get into the but-for hypothesis. If you wipe out all the consequences of the illegal acts, maybe some of those are those market restrictions or that also have reduced value. And so those can be incorporated into it. But I think that is probably driven by that separate legal norm rather than by the fair market value standard as such. I think fair market value as a concept just does a little less work than the public international law rules themselves.
I see that the discussion seems to be revolving a lot around what role public international law has to play in defining compensation standards as we know them, and of course the full reparation standard. I think a related concern that might arise in this case is we now know that the full reparation standards They essentially originated from the seminal case decided by the PCIJ, the Shores of Factory case. And that was a case about taking of assets, so an expropriation, so as to speak. When we are dealing with questions apart from expropriation, so breaches of FET, MFN, non-discrimination standards of other kinds, how do you think that standard needs to be adjusted, if at all, to accommodate for the fact that the investor still retains the asset, perhaps just with a diminished value of the investment?
Vishakha, thank you. I would like to start on the discussion of this issue. But first, I want to thank the organizers for setting up this conference, which addresses some of the cutting edge issues as they relate to the case and beyond. So in the specific issue of what happens and how the but-for approach should be adopted for a counterfactual that is involving non-expropriatory breach, particular challenges are presented by claims of denial of justice or FET violations that are based on the alleged unfair and inequitable treatment, for example, of an investor who that did not get a particular license through the administrative process, and sort of what happens in the but-for. And I want to start with what you said, which is the starting point must be the full reparation standard as it was announced in the Chorzo factory case. And that goes to that, often cited language that the reparation must, as far as possible, wipe out all the consequences of the illegal act, but also reestablish the situation which would, in all probability, have existed if that act had not been committed. And that's the but-for analysis. And this analysis has been recently applied by a NAFTA tribunal in the Clayton versus Canada case. And notably, in that case, it was Canada that invoked that but-for analysis in order to establish that the investor was actually not entitled to any damages. And the case concerned unfavorable administrative treatment experienced in connection with the case submitted in support for a proposal to operate a quarry in Nova Scotia in Canada. In the liability decision, the tribunal held that Canada breached its FET obligations as well as national treatment provisions because it failed to afford the investors and the investment with a fair opportunity to have the specifics of their case, the environmental case, as assessed and decided in accordance with applicable laws in Canada. And then in the damages phase, as I mentioned, it was Canada that posited the but-for, arguing that even in the absence of what the tribunal found was Canada's liability was investor did not demonstrate that they would have necessarily obtained the license. And they presented a number of experts, both on Canadian law and environmental law, to demonstrate that in that but-for world, ultimately the investor would not have gotten the project and therefore was not entitled to obtain $500 million in damages for lost profits. And lost profits would have really been generated if the investor actually succeeded in securing the project. And there, the tribunal really, in that damages decision, really outlined quite nicely sort of how the but-for can be applied in this sort of scenario. And there are several passages that are particularly notable. And I, since I don't have a PowerPoint presentation for this, I want to draw attention to some particular language. For example, the tribunal, looked back at the Chorzo, looked back at the genocide case from the ICJ and said that what they're confronted in this case, the investment arbitration case, is whether there is a factual uncertainty about the investors actually getting the project. And they said that it is entirely possible that the same outcome, which is that the investor would not get the project, would have obtained even in the event that the environmental assessment process had been conducted in full compliance with Canada's obligation under the NAFTA. And so in ultimately, the tribunal only awarded a fraction, which was 7 million, for what it held to be the value of the lost opportunity, which is another type of damages that tribunals have been awarding investors in certain circumstances. And I'm not going to go into sort of specifics of how that damage was awarded, but the important takeaway from this case is that the investor could not establish, even in the but-for world, that it was entitled to $500 million in lost profits, precisely because it couldn't demonstrate that it would have gotten the license in this perfect world where Canada treated it in compliance with the treaty. And there are other tribunals that sort of have done this similar analysis. For example, the Rompetrol Romania case. In that case, the tribunal emphasized that the claimant had to establish by the appropriate standard of proof that there was a sufficient causal connection between the claimed illegality and asserted loss. And in that case, as some of us probably involved irregularities during a criminal investigation. And that process included the attachments of shares and the arrest and attempted imprisonment of top managers of the company, which was all found to be in breach of the fair and equitable treatment standard. And the investors sought, among other things, as damages, legal costs incurred in dealing with the wrongful acts of the Romanian investigators and prosecutors. And in that case, tribunal emphasized that it had to decline to find that the criminal investigations were per se illegal. And they looked at the certain expert methodology that was used to show, what sort of would have happened in the absence of the treaty breaches. And they concluded that the claimant had not shown that it wouldn't have incurred its losses, including legal fees, had the respondent not breached the bilateral investment treaty. So it's sort of similar to how the Clinton Canada tribunal approached it. And same approach has been applied in the denial of justice cases. And here I'm thinking about the older case now, Chevron versus Ecuador commercial cases, which involved a claim of denial of justice based on the fact that the Ecuadorian courts have not adjudicated a number of domestic cases that were brought by the investors against Ecuador under certain contracts. And the tribunal there found that compensation may only be awarded if the claimants are able to prove that they would more likely than not, and that goes to the Chorzo factory, right? Or more likely than not have prevailed on the merits in their cases before the Ecuadorian courts. And in other words, that the tribunal believed that the underlying claims have merit and should have been accepted by the Ecuadorian courts. And in particular, in that case, the tribunal found that in the but-for world, claimants would still have incurred legal fees that they incurred in the actual proceedings. And so the legal fees were not awarded as part of the damages. So these are the sort of different ways in which the chores of but-for analysis have been applied in the non-expropriatory violations. And I have other comments on this.
If I could add, but what you see, I think, Diana, in all those instances is adherence in principle to Chorzo. And remember, the basic framework of Chorzo is wipe out all the consequences of the illegal act, restore the situation that would have been in place. Restitution, if it's possible, is kind of primary relief. If, as a practical matter, you can't give actual restitution, then a sum of money, the equivalent that would be the equivalent of restitution, plus the possibility of damages. For an illegal act, you can add damages, and that was the whole idea that it wasn't just a lawful expropriation against which some kind of compensation was due, but you could also have damages. But I think what you're getting at is that tribunals, and correct me if your analysis is different, is that in all these instances, FET, denial of justice, impairment, other standards that might apply in addition to expropriation, tribunals are showing fidelity in principle to the Horzo factory general standard. The question becomes, how do you apply it? And a lot of the stress then gets put on kind of causation. What illegal acts caused, how did the illegal act affect the value of the investment and diminish it? So what is it that actually needs to be wiped away? What consequences need to be wiped away to get back to the original situation? But I think the principle is widely applicable to all manner of treaty breaches. Do you agree with that?
No, Mark, I agree. And I think that when we, particularly, representing states, would now invoke this principle, because it works both ways, claimants invoke it and respondents invoke it. What would have happened in the absence of the treaty breaches? And the challenges are, and I think for tribunals as well, how far do you go in this counterfactual? And I think the Canada example is really interesting because Canada did submit a number of expert reports essentially positing what would have happened in the but-for world, and was able to counter the investors' but-for proposal that they would have gotten this license anyway. So I think that absolutely, I think the but-for is a very important argument that remains, and you see it being argued in all these cases that don't involve expropriation.
I'm curious, as I'm hearing this, I understand that there seems to be some amount of unanimity between the panelists about the sort of extension of the full reparation principle to non-expropriatory context as well. But both Mark and Diana, you touched upon in the difficulty of constructing a but-for counterfactual, sort of assuming some things away. Now, if we take the example of, let's say, a developing state or a state in early stages of development, which perhaps doesn't have quite the infrastructural ability or the political capital at its behest to constantly be affording the kind of rights that investors have now come to expect they will be afforded. If you have a state with perhaps a history of expropriatory conduct, a crippled judiciary, if we talk about the denial of justice context, how would one go about constructing a counterfactual to do a but-for analysis in those cases? And of course, the question is open to all panelists who want to chime in.
I have some views, but perhaps I should, I feel like I've been speaking quite a lot, and so I prefer to defer to my other co-panelists at the moment, unless, but I have views about that.
Well, Mark, perhaps you could start, and then others could comment on your views on that.
Sure. I think that the line that tribunals have sort of drawn, if you look at the decisions are not uniform on that very tough issue. I think there's some parts of it, you could view it as sort of a spectrum of what you assume away and what you don't assume away. And a lot of the harder questions where tribunals divide might be thought to be in the middle of that spectrum. So easy stuff that you assume away is what I mentioned before. For example, the state announces a week before they expropriate that they're going to expropriate, and your valuation standard is fair market value immediately before the expropriation. So it's not just immediately before the expropriation. You got to go back in time to the point before the expropriation became known to the market, because it's that very illegal conduct that you're challenging in the case that you can't allow the state to use to sort of diminish the value that it would owe. I think there'd be pretty wide consensus about that application of that rule. At the other end of the spectrum, you have, the situation you were describing, Vishakha, that the state generally just has poor administrative systems, low approach to rule of law in general. That it has some vagaries in how it carries out its administrative duties. Would you assume that, sort of think that this developing state suddenly had all of the, the worked with Swiss efficiency, and that it had to be Switzerland in order to meet the international law standard. I think most people would say, no, you don't really need to assume that either. So the harder questions kind of arise a little bit more in the middle. And this came up in a lot of the Venezuela cases where, Venezuela started, did a lot of expropriating and still, has over many years did a lot of expropriating of assets. And so it came up in some of the cases, does a general proclivity for expropriatory conduct count? Even though there have been many cases that have found that expropriation required compensation or was even illegal expropriation. So does a pattern of essentially questionable, dubious, and maybe even, according to international tribunals, illegal activity in other cases, not in your case, but that would affect the market, how a market participant would think about an investment in Venezuela, could Venezuela use that to say, well, the value of any market value should be reduced, or the discount rate should be so high that it effectively reduces the market value. And so I think it's that middle ground where you start to get into the particular additional conduct of the state. And what I would say is this, that I think in general, and I'm subject to comments from others on the panel, to the extent that there are particular measures that are targeted at that particular investment, it's a little easier for tribunals to sort of find that's illegal. There's another, they impose some new, this came up in one of the Ecuador cases that we handled, where the state imposed after the fact some new laws, and then it said that would have reduced the value of the investment. The tribunal said you can't use your own laws targeting the investment, even to reduce the value of the investment, even though those weren't the subject of the arbitration. But to sort of say the more specific it is to that investment or that sector, the easier it will be for tribunals to kind of disregard it in the but-for hypothesis. Whereas the more it's about general market conditions, I think the harder it will be for tribunals to discount it. But again, I mean, others may have views about this.
Perhaps I could add a little bit on denial of justice cases. Unfortunately, I cannot comment about any of the current cases, but even look, and it is a body of law that is not as extensive, obviously, as expropriations. But looking back at some prior cases that are now fairly old, including the one that I mentioned, the commercial Chevron versus Ecuador commercial cases, the tribunal essentially had to decide what would have happened in those cases. They looked again at expert evidence of Ecuadorian law, on valuation, and they came up with what an Ecuadorian court would have decided in a treaty-compliant world. And that was the damage awarded. The only thing that the tribunal did not award is legal fees, because they said, well, you would have incurred them anyway, even in the absence of the treaty breaches. And Professor Jan Paulsen, in his treatise on the denial of justice, explained that in these types of cases, in establishing an amount so that it corresponds to what the international tribunal feels was the true loss, it may be necessary to evaluate probabilities of the outcome if the local system had proceeded in accordance with its laws, but without violating international law. And so that, again, takes you into this, what would have happened. And we had language in the PMI Uruguay award where the tribunal affirmed that principle. And even though they did not have to do it in that case, but they said what a BIT compliant domestic court would have decided is an appropriate factor for the assessment of damages in the denial of justice cases. So in that particular context, it may be required for the tribunals to actually, in a way, step into the shoes of the domestic court and see what were the probabilities of certain outcome. Otherwise, there is a risk that the investor is gonna sort of avoid the risk of litigation entirely, and it will be overcompensated. So I think these are the the types of issues, but ultimately it does turn on the specifics of each case. Tends to be fairly complex, and there are many other issues that sort of come up in which facts you assume, which facts you assume away. And I think that from, that, as I said, fairly limited body of law, you see that the tribunals are still, struggling with some of the principles, like the whole idea that the composite act theory, which you see in the articles on state responsibility, somehow applies to denial of justice, is highly contested. And it's been the position of states in our cases that a denial of justice can, by definition, is not a composite act. And so, I think this body of law is evolving, and I think that you'll be probably seeing more of, principles applied in that context.
I know Diana mentioned just now brought in the point of composite acts and how compensation determination may work in those cases. So still speaking in the context of the but-for analysis, at what point would you then start the creation of the counterfactual, or at what point in those series of actions that you talk about would you consider the act to have begun or been consummated in the context of composite acts as we understand them? I think under Article 15 of the Articles of State Responsibility. I'm not sure if Martins wants to comment on it, given his recent work on the Articles of State Responsibility, but yeah, the floor is open for the panel to discuss this.
Oh, Martins, I think your sound is off.
Yeah, I can't hear you, Martins.
All right. Can you hear me now?
Yes, that's perfect.
Wonderful,
thank you.
Wonderful. I was just, adding my voice to the gratitude of my co-panelists. I was just sort of scribbling. I hope that our wonderful co-chairs would not mind. I was just scribbling some international law notes, listening to the wonderful perspectives of the practitioners, and really finding that I'm completely on the same page with them on all of those things, even if perhaps thinking about it slightly differently. So one thing that struck me as perhaps the discussion has moved on, but just to show that I'm not merely listening, but thinking on as well. So I thought that Mark was I really view it very similarly on the market value and fair market value. And I suppose to pose it in analytical terms, probably what we are thinking about here is the question in terms of Vienna Convention of Law of Treaties. What is the ordinary or special meaning of the particular term? So we would probably have to engage in the intellectual inquiry whether states in general, when they have used one adjective or the other, have tended to attribute a different kind of meaning in this particular sense. And my instinct, if we were to look at varieties of treaty practice, non-disputing party submissions and such, is that we will probably arrive at a negative conclusion. That is, if states want to inject a difference in the valuation standard, even going historically, they would not really do that at the level of the adjective, but rather in articulating considerations that explicitly are to be taken into account or not taken into account, both in more recent treaty practice and going back to the great Cold War battles. So I think probably the consequence is that tribunals on this point have got it right. I think, I think it's probably kind of really, I hope, a harmless perk on my side that I like to pronounce the factory in its original Polish name, Horsów. I think that Judge Crawford is the only one whom I have heard doing that, but that is not the worst pedigree within which to set a state responsibility argument. And I think, yes, I mean, I think that the point is right, that for reparation is the guiding light. I think I always slightly, perhaps not quite tremble, but I think that there is the footnote to be noted if we look at it through the lenses of the Articles on State Responsibility, of course, in a technical sense, Part 2 is not directly applicable in responsibility that is implemented on behalf of actors other than states. So recall, articles on state responsibility have three parts. The first part says, was a state naughty? The second part says, what follows? And the third part says, how can another state go about implementing it? And the great hidden provision is Article 33.2, which says that articles are without prejudice to cases such as investment arbitration. And analytically speaking, we can probably think about the interaction, how the jigsaw fits together in two ways. On the one hand, we could say, as Mark wonderfully quoted from Hart, the Permanent Court of International Justice, that everything follows from the breach. So sort of the idea that the type of beneficiary is irrelevant, you get the full package from there. Or you could equally say, perhaps in a slightly natural law light sort of way, that we know what interstate responsibility rules are. And on other points, we apply it by analogy, looking whether the structural assumptions of investor-state dispute settlement justify giving a different bent to the state responsibility rules. And actually, I think that Crawford was not unsympathetic to the analogy point. If one reads the MTD Annulment Committee carefully, I think that the way how he gets at application of Article 39 is by saying that the context is analogous. And I think that there are some points within Part 2 where it is very hard to see how the reparations could apply in investor-state arbitration. So satisfaction, which is a remedy reacting to injuries to owner of states, it's extraordinarily hard to see how that could fit where an actor that is a non-state actor is a claimant. So I think that that is probably where the cases like Quiborax and Bolivia a bit nodded off. But compensation, I think, is rightly viewed as falling in this context. But again, I think a background, there's always the possibility of some light calibration. On the but for, I think I would probably only add, I think, again, really saying the same point in perhaps slightly more complicated terms as befits an academic. I thought that the Pay-Casado 2 tribunal did it in unsurprisingly mercilessly sharp terms in light of its chair, that injury is really the first thing that we are looking at. We have to be clear of what the injury is. It is not generalized loss that is being compensated. It is injury identifiable breach that has injured the non-state actor from which the causality follows. And I think that that is sort of the lens through which other things are filtered through. And I think that I agree with Diana that what one might loosely call procedural rules pose all across the board in public international law hard questions, and there are lots of interstate cases where the consequences are not thought to justify compensation. And probably throwing in another point where some might think that investment tribunals have perhaps sometimes been a bit too hasty, the rules on protection, right? Also something where in interstate context, tribunals have sometimes been a little bit hesitant in identifying causality between the failure to prevent and the damage actually caused. You know, not without controversy. I'm thinking of Bosnian genocide and such cases. And it's interesting that we sort of landed with the composite act and denial of justice, which really occupies an interesting place in the whole articles on state responsibility, because probably there's one place that was so terribly badly done, that was it. Why was that the case? Well, you know, we respect the great and good, but we sort of all know in kind of in the friendly international or gossip way that the great Roberto Ago, a genius as he was, could never quite get over having lost phosphates of Morocco. And therefore, he tried to re-argue the case as being a special rapporteur by trying to present exhaustion of local remedies as substantive, not a procedural consideration. And principally derailing the ILC project for about a decade and making everything written on exhaustion of local remedies from 1960s to 1990s extremely problematic. And that is where it comes. And I think even in Ago's thinking, this was not even composite. It was a complex act, something that fortunately was deleted as a concept in the second reading. So I think I would probably be a bit cautious on reading it too readily. I think we have to take ILC articles seriously, but we also have to appreciate where they have slightly weaker spots. And I think that this, again, may be something where they're slightly nodded off.
Thank you, Martins, for your comments. So I believe, Mark, you wanted also to take the question from the audience. So if we're fine with that, there was a question of how should tribunals basically deal with the situation where the treaty stipulates clearly that the applicable standard is the market value standard, and how is it possible to still have a fair market value, sort of in reliance to torso factory. I am pronouncing it probably wrong, but still. So do you want to take this one?
Sure. I think it's I appreciate questions from people who are participating. So please send them in, and we just want to be sure to address it. I think it's a little bit of it's a good question, and I think it's a little bit of closing the loop in light of the comments we've already made, the panel has already made, myself and others, including Martins, in those last comments. I think if you have a treaty that has a particular compensation standard or rules for compensation, well, I mean, that's lex specialis. I mean, that has to be, taken as the agreement between the states. And so it may derogate from the general rules of or principles of public international law. And that's open to states to do as an analytical matter, so they can. The question then becomes sort of giving that meaning, though, in the context of the treaty and a particular dispute. And then it falls to be interpreted maybe under the Vienna Convention, as Martins just said. And so you need to look at the language and then look at whether there was a particular meaning that the states ascribed to it. And then you would need to look at, I think, assume that the states had ascribed a meaning to it where they meant market value could be different than fair market value in some way. Just posit that for a second. And they meant market value as having a precise meaning, which they may, I mean, your treaty analysis may not conclude that to be the case. But if it did have a precise meaning, then the question would be, well, how does that apply in the circumstance of this case, where we also have other generative public international law rules about compensation, including that the state can't benefit from its own unlawful conduct. And so I think that if you work that through that kind of three-tiered analysis, once you get through each filter, you're going to kind of end up at the place in this circumstance where market value and fair market value may not be very meaningfully different from each other in the context of an investment case. But I think that's sort of the method of analysis by which you get there. I don't think you can simply throw out the idea that the states chose particular language in a treaty, but you'd have to do an interpretive analysis of what did that mean? And then how does that meaning translate to this context of this case, along with the other rules that also clearly do apply to this case, and that the states didn't, I think, mean to also then exclude.
Right. Sorry, David, you were gonna follow up. Please go ahead.
I wanted to say something, perhaps we moved on from that part, but about Diana's presentation. I think I definitely agree that the torso factory rule of full reparation envisages in itself certain degree of flexibility, and the court, the PCIJ itself alluded to that, especially with respect to linking the reparation standard to the manner or the way in which a particular primary obligation is breached. So it's not a fixed standard that since a certain thing, that certain measures constitute an unlawful expropriation or a breach of international law, that the standard will always be the fair market value of the entirety of the investor's business or a non-state actor's economic interests. But the court drew a distinction between the expropriations that would be lawful but for the payment of compensation. So only thing that makes expropriation unlawful is the non-payment of compensation, and expropriations that would be otherwise unlawful. Full expropriations that didn't have a public purpose, for instance, in which case the entire act of expropriation or the taking should be assumed away from the but-for scenario, and which affects the valuation. Obviously, this also applies to FET violations, because FET violations can also take place in different ways, and different things can be wrong with a particular measure that violates the FET standard. For instance, certain regulatory change, which by its nature has a legitimate public purpose, but is wrongful simply because not enough transitional terms were offered to investors to adjust to the new regulation. Obviously, in the counterfactual scenario, there is no reason why we should assume away the entirety of the regulation which had a public purpose. But with this type of flexibility, I think, comes certain limitations as well, and that is precisely where the tribunals probably should be careful not to encroach on certain mandates that are exclusive to the state as a policy maker. For instance, in some cases, it has been done that the tribunals have assumed that but for a particular breach, in all likelihood, the investor would have acquired a certain license, for instance. But probably the tribunals should be careful in these instances where this is a discretionary power of the policymaker, of the executive, whether to grant a specific license or not, and not to encroach on that mandate by assuming that but for a particular procedural violation, for instance, the license would be necessarily granted. Also because to do so would conflate what types of interest the investor had already acquired. Perhaps the investor has a legitimate expectation, but if we compensate legitimate expectations in the same way as if it was an acquired right, then the distinction between legitimate expectations on the one hand and the acquired rights which give rise to the expropriation standard or a possible violation of the expropriation standard would be blurred. And in that sense, I think it's more important for the shores of factory rule to be somehow pegged back to the primary content of obligations that are being considered before the tribunals. That's pretty much all.
Thank you so much, David. So I would suggest that we move on because we have a lot of ground to cover, and unless, of course, there are objections from you. So the next question we wanted to ask you is about the factors that influence the selection of the valuation date, specifically in the non-expropriatory context, but perhaps in the interest of time, not so much generally, but more so, in relation to this year's problem. Which factors influence its selection in the context of violation of a creeping nature, creeping violation of the FET, if such exists at all. And I have a practical question, if time allows, after this on the same point. So whoever feels like responding to that.
I can kick it off. I mean, there's, I think in terms of where you have a creeping expropriation or a creeping FET breach, which I think was, has been sort of recognized a bit. I think was it El Paso versus Argentina, where there was the recognition of this concept of kind of a creeping, I think in the annulment decision, the creeping FET, which to me makes sense. I can see people having a problem with it, but I think it sort of makes sense. But in any event, I think it becomes, I don't think there are precise rules about how you would calibrate a date where you had a whole series of measures that over time caused the injury. And I often, in cases, I've often found it useful then when you have that circumstance to go back to the general standard as, right, because all of this is supposed to be, I mean, finding a date is a very precise important, hugely important. But I mean, in Yukos, the valuation date was a $40 billion issue. And so it can have massive consequences in individual cases. But particularly when you're talking about, a pre-expropriation date, maybe where where something happened over a period of time, I think you want to have reference to the general standard that what you want to be doing is wiping out the consequences of that series of illegal acts. And it doesn't necessarily, you could have a conceptual argument that it's before the very first of them. But of course, if you go back to that time, maybe the whole train of events wasn't foreseen. And doing it at the end of them seems like it's the culmination of them, but may not. Then you're allowing for diminution in value that took place as the pattern became clear over time. And so I think there's a lot of discretion on tribunals' part, kind of figure out where it is, but in light of the idea of wanting to give wipe out the consequence of the illegal acts, if there was some point at which the acts became sufficient enough that maybe they didn't yet amount to a breach, but they started to really diminish the value, and you could prove that in some way or argue it in some way, then that might be the relevant date, because that's the date at which you shouldn't start discounting value, basically, in order to, otherwise you would not provide full reparation.
If I may add on this, sorry. This discussion between the ex post and ex ante value has its place in quite a prominent place in the non-expropriation analysis and how you compensate for the expropriatory breaches. But I should say that it is harder to conceptualize that distinction in the context of an FET violation, because in the expropriation context, the rationale of having this distinction is that when the expropriation, and precisely drawing from the shores of factory analysis, when the expropriation is unlawful only because it lacks compensation, so it does not meet this primary obligation of compensation, which is built in the expropriation standard itself, then all that would suffice to make this expropriation lawful would be for the states to have paid that compensation at the time when it took the expropriatory measures. And therefore, when we are constructing the counterfactual, we are taking the value of that asset, which was expropriated at the date of the expropriation, because that would have been sufficient to render that unlawful act lawful. But in the context of an FET violation, that is more difficult to do, because there usually you have a measure which is tainted because it is illegitimate, it is not arbitrary, discriminatory, or does not comply with due process, or is against the investor's legitimate expectations. In that case, that measure should be sort of assumed away, to use the terminology, from the but-for scenario, and you are necessarily looking at the ex post value in terms of how much the investor's asset has been reduced. And there it is difficult, or at least more difficult, to see where the ex ante value, or the value of the investor's business at the time of the expropriation, would come in. Perhaps other panelists have clear ideas in terms of where the FET could factor in this ex ante value of the investor's property.
I was going to say that I think Martins raised a hand earlier. So yeah, please go ahead.
Thank you. I mean, I think it's really a small footnote, and I think I was very pleased to hear that Mark mentioned El Paso on the composite breach. And I mean, I genuinely, when I read the decision and the annulment committee decision, I had sympathy for that. And then, as I often do on state responsibility, when I read what Crawford's tribunal thought of that, who had a different view, I decided that that view is a better one. So perhaps a little bit doing a bit of peer pressure there. And I think the point that he made in Blussoon, and upon reflection, it must be right, that the concept of composite act requires us to identify a primary rule that sets at a definitional level a number of components that need to be satisfied, while in the creeping context, we are really thinking about it in terms of secondary rules. We are really thinking about multiple acts of attribution that reach the single level at the primary rule. So I think that would probably be the criticism, that El Paso confuses primary rules and secondary rules and imposes factual peculiarities of particular case at the level of definition. But I sort of to return to the point, I can see how denial of justice could be the one animal that, albeit in a negative way, sets possibly exhaustion of the full regime as it were the breach and the failure of the full regime as two aggregate components at the primary level. But again, with the qualification that denial of justice in articles is so messed up that one has to be extraordinarily careful in trying to get anything of value out of that.
Martins, though, I mean, forgive me for pressing a scholar to deal very practically with the situation, though. But if you have a situation where over the course of a year, the state takes a series of concerted measures, no one of which is, you would say by itself is a big deal, but it carries out a course of conduct that over the time ends up making it impossible for the investment to continue because they restrict access to the facilities, because they put a requirement on it, because they try to recut some kind of concession deal, because they impose an additional tax. It's the death by a thousand cuts kind of hypothesis. And the tribunal finds that it's been proven that this was part of a concerted set of acts. I don't think you disagree that could be a violation of FET, even though it didn't take place as just one discrete act that by itself was sufficient, right? And that's really the part of El Paso that I thought made a lot of, or that concept that made a lot of sense. But maybe, I don't know if you agree or disagree with that, but I would think you would agree that if that could also generate liability for an FET breach.
Right, so I don't have a problem with that. And I think, Ron Petrol was mentioned as, again, peculiar in its own way, but I think really the general proposition that we have to look at the entirety of facts.
Right.
The kind of going back, to GAMI and Mexico and such, that we have to judge them together. And I think analytically speaking, there is nothing that would preclude us from thinking of a primary rule that requires each individual act to reach the benchmark, or that would consider them in general. So I suppose in the law on the use of force, it is one of the perennial debates whether pinpricks accumulate or not. So I think that is right. But so perhaps it's really more of a footnoted pedantry that that composite breach doesn't really help to get us there, with the possible exception of denial of justice.
If I could also comment on that, I think that it's hard to see how a denial of justice can possibly be encompassed within the notion of a breach consisting of a composite act, as it's defined in the articles on state responsibility. And it's not least because in the words of the commentary itself, composite acts covered by this article are relate to the breaches of obligations which concern some aggregate of conduct. And that is not how a denial of justice occur. It is not an aggregate. It's something that happens once the system as a whole fails. And so, that's just an observation about whether denial of justice should be morphed into this composite act theory. But on the specific issue that we've been discussing, the date of breach and in instances that involve either creeping expropriation or creeping FET, the El Paso tribunal itself noted, even though it found a creeping FET violation, that there are certain measures that had to be excluded from consideration of damages because they did not result in any significant damage. And so that's at least the recognition that just because a particular act was found to have fallen within this FET violation doesn't mean it would have to be considered. That doesn't provide a lot of guidance, but it is a recognition that you can't just put all measures that were taken and assume that they all caused loss for the purposes of the date of breach. And but I also think that some of the jurisprudence on creeping expropriation is illuminating here. So there are cases that, as you know, involve findings of creeping expropriation, and they're sometimes viewed as composite acts under Article 15. Explicitly, the tribunals refer to them. And I'm thinking about Siemens versus Argentina, where the tribunal found that the expropriation was a composite act. And but then it found that the actual assessment of damages had to be done at the point when sort of the last in a series of acts occurred. And it really, after describing, all these measures that sort of culminating in the issuance of a particular decree that ultimately resulted in the expropriation, the tribunal then proceeded to tie its award of compensation to the date of the culminating act of the expropriation, and not, in the words of Article 15 of the Articles on State Responsibility, to the first of the actions. So that's one case. And similarly, in Compañía de Aguas versus Argentina, again, the tribunal sort of did apply Article 15 of the Articles on State Responsibility and described a particular series of conduct that led to the expropriation. But once again, it tied its award of compensation to the date of expropriation, which was the last sort of act that triggered what it found to be the creeping expropriation, and not to some earlier impugned actions. And I think that is consistent with how we think about, breach coming to a being, becoming actually a breach, being consummated, being completed, and that damages do not arise before the breach is consummated. So I think these are just the illustrations of how the date is, something that actually falls. The assessment of the damages falls upon the completion. I think the application of it in the FET cases should not be different.
Thanks, Diana. I mean, it's fitting that the discussion has circled back to the guidelines that the ILCR provide us. And perhaps this brings us to one of the last, but certainly not the least important points of the discussion, which is when we're talking about the full reparation standard, to what extent does the financial capacity of the state to pay damages, to what extent should that be factored in? I mean, keeping in mind that we now have awards that run into billions of dollars. We've had where a state has had to tell the tribunal that it would be charged the entirety of its IMF lending if it were to pay out the award to the investor. So to what extent should compensation that is inherently crippling for the state be something that states should be required to pay? And perhaps Martins can take the lead on this, given his very timely paper on crippling compensation in international investment law.
Well, thank you. That is very, very kind of you to say so and to single it out. Available open access on Exit Review website. Yes, I mean, I think just sort of to tie my thoughts on the very exciting discussion. I mean, I think sort of again, perhaps sort of pulling out of investment arbitration, where of course arguing cases is the daily bread and butter. I mean, ultimately, in public international law sense, these are subsidiary means for determination of rules of law. We're here mostly dealing with custom. And ILC conclusions on custom in 2018 sort of tell us that we have to look at the quality of reasoning, but ultimately what matters is a subsequent reception and endorsement of states and scholars and everything. So I mean, I guess probably from a longue durée perspective, I usually tend not to overplay the incredible, ingenious, hidden insights of things that were decided 20 years ago in a slightly different world or 100 years ago. It's sort of in the in the process, I think it ultimately matters what survives. And I think possibly the first decade of investment arbitration, even in many of us think it very exciting because then we found investment law might perhaps be of slightly lesser quality than some of the more recent things. Right, so Vishakha asked the question about crippling compensation. And that is something that sort of came to me as an intellectual query when thinking of some of the great recent cases. Obviously, one case that has been mentioned regarding Russia already is not the smallest case in the world, but there have been others also more recently against Pakistan, against Egypt, against Ecuador a few years ago, and also against Venezuela. Some of those actors might have some problem in satisfying the full amount of the award and providing public goods to the people. And so the question that I was wondering about is whether that is a legally relevant consideration, or is that an important but not legally directly applicable policy point of the sort of saying, look, you have to be sensible, let's be realistic. Here, and perhaps for that reason, it's a great moot court point. One can really plausibly look at it in a number of ways. One could say on the one hand, well, what did the International Law Commission say about it? An International Law Commission in its articles, by necessary implication, says that that is not a relevant consideration. Why was that the case? Well, if we dig in the discussions, we see that the great James Crawford looked at it and from the purview of late 1990s said, well, mostly cases are trivial. And he was thinking mostly about regional human rights cases. When large claims do arise, we can trust states ultimately not to be silly and not to push these cases forward. They don't want to cripple their neighbors. If they do push them on, perhaps international community will be wise enough to adjust something. And so there he's thinking about UN Compensation Commission in Iraq. And ultimately, we might have necessity and force majeure and distress to help in and maneuver them out. And it seems to me that most of those underlying assumptions have been questioned or fully falsified. So we do get very large cases, also in interstate context. The fact that investor gives direct claim rights means that sort of the public law logic that states have the enlightened interest not to blow up the whole system because they are repeat players no longer operates. International community is perhaps not where it was in the 1990s, and necessity is not the most effective argument for states to invoke. So in a way, so the normative assumptions fall away. Well, what are the implications? I think here, so the counter answer could be, well, yes, but ultimately the real question is, what did states make of it? If we take custom making seriously, we have to see whether states have argued against the point, whether they have included something like that in submission. And here, and again, such a wonderful collection of practitioners, very happy to be called out on incompleteness of my analysis. I think that since the great CME case, at least as recounted in arbitrator Brownlee's separate opinion, probably in the last 15 years or so, no arguments of that nature appear to be presented. So the possible answer is, well, who would otherwise argue that if states, the most interested actors placed with $1 billion claim, do not sort of, what clear, as it were, opinion non-jurists to be pretentious about it? So that is sort of, I think, where we are. And it's interesting to imagine the crystal ball where the next few years would go, because things are sort of in motion. In interstate settings in the International Court of Justice, my article in the Modern Law Review was invoked by Alain Pellet on behalf of Uganda in the armed activities in the territory of the Congo, where Democratic Republic of Congo asked for $12 billion. So obviously it is one state. The other state did not sort of set the argument aside. Perhaps my wonderful colleague Philippe Sands, with whom I teach international courts, did not want to be too dismissive of my writings, but well, I'm kidding. I'm sure that he would have dismissed it if he wanted to. So I think that there are interesting things there. Ancitral has put it as one of the things that states could comment in the reform context. I mean, ultimately, it will be interesting to see. There are plenty of good reasons of saying that that is a bad and damaging idea. Unpredictable, how do we really implement it in that arbitral setting, confidentiality rules, how do you make such hard determinations? I think ultimately probably where I come down from is that it's not what one would draft thinking about it from the scratch, but I think that that is an issue, and it is hard to see not a more satisfactory, but a less unsatisfactory place in the argument to inject it. So states might very well not find it interesting, or they might find it. And I think that that is really more of a long-term process, and finding such an exception would be, broadly speaking, consistent with the bigger fabric. And I think contribution to damages is one example that people a decade ago were very skeptical about. I think now people are perhaps a little bit more comfortable with having a vague principle that sort of acts there at the very end of analysis. So that would be my pitch. Not necessarily right, but interesting.
Perhaps other panelists would like to chime in about their thoughts. Maybe you could also take into account one of the questions that we have from Chris Campbell, who is the director of the FDI Moot, talking about whether it would be better to consider the idea of crippling compensation at the enforcement stage, so something akin to municipal bankruptcy proceedings, rather than at the decisional stage when the tribunal decides on merits and damages. So yeah, the floor is open to everyone to chime in.
Could I just very quickly answer to Chris's point and then to leave myself open to being demolished? I think that is a perfectly plausible way of going about it. And I think that that is what, I think it was Tetyan versus, I think it was ConocoPhillips versus Venezuela, which sort of seems to allude to something like that. The trouble is that it doesn't seem to chime very neatly with the enforcement regime that we do have, which, one of the crown jewels of the system, at least within the ICSID context, doesn't seem to permit that. So I think, again, if we think about domestic law analogies, there's some things that we would do in domestic law but don't fit international legal order, and that seems to be one of those. So we have to look somewhere else.
Yeah, if I could jump in here, first of all, I thank Martins for a very interesting and thought-provoking article, and I completely agree with the last point that you just made, that I think we do so much more violence to the enforcement regime for international arbitration generally to start introducing basically second-guessing provisions at enforcement jurisdictions about amounts of liability. It would be, I think it would be a complete disaster for international arbitration. Equally, I mean, and look, I confess that my practice has been to represent claimants more than respondents, although I've represented both in investment arbitration. And I should disclose that I was counsel that argued the damages issues in CME, Tethian Copper, and the Ecuador case, Parenco versus Ecuador, that you mentioned and that you cite in your article, Martin. So clearly I was advocating for, in each of those cases, I think even more compensation than the tribunals awarded. But look, I do think that this is a system that has to be based on rules of law. And of course, it also needs to respond to questions of justice. But the idea of a standard as vague as crippling liability and states have phrased it in different ways, they do argue the point, not in the way that you've articulated, I think, in your article, in fairness, but they do argue and try to make the tribunal sensitive to the consequences of what a large award would do. It's more than our entire education budget or whatever. It can't possibly be the case. And so those arguments do, at least as an equitable matter, already come in. And I suspect that they weigh on the minds of tribunals, but in an appropriate way, because I believe what it does is weigh on the minds of tribunals to be sure that they're pretty rigorous in their analysis of what the full reparation consequences are. And I think if you also think of this, I get the idea that the articles of state responsibility have, are without prejudice to investor-state conduct. Now, I don't think people have fully worked out. I think there's sort of an implication by that the compensation in the investor-state context can therefore be less. Arguably, it should be more. I mean, the purpose of investment law and investment treaties is to try to attract investment to drive economic results in a country. And if you're not prepared to, if you are inviting private actors who have much less power against a state, frankly, than another state does, to come in and put their capital at risk, and be protected in a very minimal way against illegal state conduct. Well, I would think that that's a circumstance where you'd want to make sure that they did get full reparation. States can often, do with much less because they are states. And so I'm just not sure the sort of implication behind this, that if there is an ILC articles exception for investment law, it ought to mean that compensation can be on a discretionary basis whacked down. I mean, you could just as easily, as a matter of principle, say it should go up and there should be a punitive component because states have induced investors to come in on false promises in the case of FET cases, or by committing some illegal act against them, which they usually don't have very good domestic defenses for. But it's the discretionary character, I think, is a very practical matter. Tribunals, we have struggled in the investment arbitration world and in the particularly to kind of get better at dealing with quantum issues in a more reliable, predictable kind of way. And I think the practice has gotten better. I mean, if you look at awards over time, the awards have become much more thoughtful and detailed, more sophisticated. I think there is a real balance of trying to, treat arguments on both sides with great fairness. And it's much less kind of finger in the air discretionary than it used to be. And I think it still needs to go further in that direction. But if you start introducing a discretionary concept of crippling compensation as a way of a discretionary reduction of damages amounts, how do you ever really apply that with any kind of principle? States invoke it in every case, because in every case, a state to be obligated to pay a private investor means it won't be able to spend that same money on other public goods. How do you deal with it in the circumstance of like Argentina or Spain now, which has dozens of cases relating to essentially the same set of measures? Is the first one of those cases not crippling, but by the time you get to the 10th, the compensation will become crippling, so they've paid enough for the renewables energy change in policy, and so the damages should be zero? Or do you, ratio it down by 50% or 20%? Is it that it would be your education budget? Is that crippling? Or does it have to be, it would hurt your defense budget, or the other way around? I mean, I get the idea that we need to have sympathy for that. But it seems to me that part of this whole enterprise is to provide discipline to states when they want to induce foreign investment. And just giving them a sort of discretionary way out that could be pled for 0 to 100% reduction in every case would create such disaster and be so impractical. It just make all cases harder to litigate, harder to predict, harder to value. And economists will tell you that all of those kinds of uncertainties increase the cost of capital and reduce investment anyway. And so you're kind of shooting yourself in the foot. So I think we need to deal with the cases as they come, and some of them are going to be large, many of them will be small or be dismissed altogether. And in the aggregate, I think we're getting better, not worse, at doing it. So I think there are just real dangers to it, although I certainly really do appreciate Martin's the thought that went into the article. It is a very interesting idea.
I was wondering if Diana, you wanted to maybe respond to that as counsel representing states, usually, and state-owned enterprises.
Probably in the interest of time, I'll limit my remarks, but thank you. Yes, I think one immediate thought that comes to mind is the system is an extraordinary concession by the state to agree to litigate certain issues, and therefore, consent and the scope of all the liability issues as well as compensation must be construed narrowly. And I think that once we start raising the issue of discretion, we have to be careful in general. That's my kind of immediate observation. But what I found to be, a bit of a perverse almost nature of the current system is that oftentimes our tribunals find that something that happened domestically where some discretion was exercised is somehow shocking, but tribunals themselves engaging in a level of discretion is acceptable. And so there is sort of this problem that we've been seeing. And I think, Mark, in that sense, I agree that having consistency and rigor in the application of the rule of law benefits both sides. So, and it makes it more, transparent for both sides. What are the rules? What are we getting into by signing these bilateral investment treaties? So I think that I'll just end here because I know we're reaching the time.
I was probably going to give the floor to David because I think, David, you wanted to speak.
Drawing on the argument on discretion, I think I find this very compelling, especially in light of this current ongoing legitimacy crisis, as it is termed in investment arbitration, which precisely, at least partly, comes from the fact that the actors generally find the discretion that these private persons, arbitrators, are afforded with. And perhaps I was asking myself whether more is to be done on the level before we get to the reparation of setting more, having more clarity in terms of the obligations themselves, rather than having this sort of a strict liability regime that we have in investment arbitration with respect to many aspects, including the principles which only look from the investor's perspective of what is the actual loss of the investor, and also going back to the crippling, creeping expropriation and the creeping FET violations, where the state's each individual conduct of the state is not really a violation of the treaty because it's neither arbitrary nor discriminatory, but together they give sort of an FET violation. Whether that is where it has to be attacked and more things have to be assumed away from the but-for scenario, whether that is the way to reduce liability, rather than affording even more discretion to the tribunals, which would probably exacerbate the legitimacy questions that exist vis-a-vis the entire system nowadays.
Thank you, David, for your remarks. I guess unless the speakers would want to follow up on that, Martins, yes.
A very brief postscript. So extraordinarily grateful for the thoughtful remarks. I think probably the only footnote that I would like to make is that I'm probably, again, pulling back in the bigger international law perspective, I'm less extraordinarily troubled by the proposition. International law is very familiar with the idea of vague rules that are elaborated by application in extraordinarily important areas of international law, the limitation being one example. Contribution to injury, I think, is also another example where in a disciplined way we can build up rules and clarity. So essentially, Judge Greenwood's declaration in Diallo, this is not alchemy, but it is possible to work with equitable rules even within the legal regime and ultimately conduce predictability. Aglaya, back to you.
I don't know, Mark, if you want to footnote that, but I mean,
in the interest of time, I would just say that I actually do think that, as Diana sort of mentioned, it's not clear to me that states would actually welcome a huger amount of discretion with respect to awarding damages, because it's sauce for the goose is sauce for the gander, I think, in this situation. And I actually think that what we need in investment law, I agree with you that of course we need to operate in constitutions as well as in international law at a general level. But I think in international investment law and with the crisis that David mentioned of confidence and legitimacy, we really need more, not less predictability. So.
All right. And Thank you. And with that, with all of the footnotes, we wanted really to thank all of you, Diana, Mark, Martins, David, of course, Vishakha, the organizers, Polina, Alexandra, Victoria, Chris Campbell, without whom, FDI would not really be. So thank you all so much. I think it was a wonderful discussion today. Personally, I've enjoyed it immensely.
Thank you, everyone.
Thanks, everyone.
Thank you. Bye-bye.